Let's start our day with Judge Simpson.
Felton.
Good morning, Your Honor. Ashley Felton for the people. Your Honor, at this time, people do waive any conflict between this honorable court and the Office of Public Defender. For the record, the people do not believe that any conflict exists. We make a waiver for the avoidance of all doubt.
Thank you.
Assistant Public.
Hey, really?
Lauren did it yesterday, so my turn today. Assistant Public Defender Natalie Pate.
She does it every time on.
I know, because she's the main one.
So who made you do it today?
Miss Joy, Miss Gaines, sorry.
I see. I actually knew that because I saw Miss Gaines there and I said, that's why Natalie's doing it.
That is correct. Making sure that everyone knows. So Dennis taking notes. I mean, Mr. Denway taking notes. So he'll be
On how to do it, it's like 20 words. I don't. Okay, go ahead.
I'll turn it into like 30. Assistant Public Defender Natalie Pate, with and on behalf of the Public Defender's Office. Likewise, Your Honor, our office does not believe a conflict exists between this honorable court and our office, but if one were to arise, we would waive such a conflict.
Thank you. And the court, for its part, also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus Kenyon Jackson.
Ashley Felton for the people.
He's on hold. Apologies, Your Honor.
No, it's okay. I saw your name and I'm like, okay, whatever.
J. Grant Miller, P58658 on behalf of Mr. Jackson. It was a late appointment. I haven't even spoken to him at Macomb County yet.
Yes, he's there. Can you state your name?
Kenyon Jackson.
Thank you. All right. So it was a late appointment and you're looking for an adjournment.
Yes, Your Honor. I'd like to get the discovery and discuss it with Mr. Jackson.
All right. Mr. Jackson, I'm going to adjourn your probable cause conference in your two cases. I'm going to adjourn them to January 15th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will continue. Thank you.
Michael, thank you for the gifted membership. Great way to start out the day, and I surely appreciate it. Thank you so much.
Case of the people versus Rogelio Smith.
Ashley Felton for the people.
Assistant Public Defender Natalie Pate, with and on behalf of Mr. Smith, who is via Zoom at the Forensic Center. Sir, can you please state your name for the court?
I'd just like to say I'm sorry about all the confusion I'll cause or all the mishap belongings or I don't want to say I'm just trying to say I'm sorry about any items I saw and mishap. I'm sorry, I wasn't in my right mind. And I'm doing better with the help of
All right, thank you. That's close enough.
Mr. Smith.
Go ahead.
Your Honor, is Your Honor in receipt of the 90-day progress report from the Forensic Center dated November 25th of this year?
I am.
Thank you.
The
Sorry.
report indicates that the defendant remains incompetent to stand trial at this time.
Yes,
Is there any other additional evidence?
nothing from the defense, Your Honor.
Anything else in the people?
I'm so sorry, Your Honor. I have nothing other than the report that's been submitted, the progress report.
All right. And I don't think our time period has passed.
No, Your Honor.
They do apply a substantial likelihood that he will attain competency.
They do. So I'll need an order, but I'll set a competency review hearing. Because February 26, 2026.
Thank you, Your Honor.
Sir, very nice meeting in Charles. Sorry, too much space in between these court dates. I'm losing a lot of things, in between. I'm losing a lot of things, family and everything. So you can just make this, huh?
I understand,
All right,
Mr.
thank-
Smith. We'll be in touch, okay? Oh, sorry.
All right, bye.
Thank you, Your
Thank you.
Honor.
Bond will continue. Court does call the case, people versus James Cobb. Or Cobb. Yeah, Cobb.
Water system, prosecuting attorney for the people.
Good morning, Your Honor. Kerma Dadush, Mr. Cobbs is approaching. Good to be back.
Good morning, sir. What's your name? Okay.
Your Honor, we don't have discovery on this case yet. We'd be asking to adjourn. I believe this is the first PCC on this.
It is. That objection, probable cause will be, can't hear over, Dave. What'd you say? I can't hear over. Okay, who are you? Oh, never mind. January 8th, 2026. Where's Anna Blevins? 9 a.m. Bound continued.
Barbara, thank you for the gifted membership. Again, very much appreciated.
No? Okay. We'll work it out. Court calls the case, People versus Perry Malone.
Ashley Phelps for the people.
Good morning, Christina Saxon for Perry Malone.
Good morning. Mr. Malone, can you state your name, please?
Perry Malone.
Thank you. What are we doing on this?
Your Honor, I'm asking for an adjournment. Ms. Feltus said they're still trying to get the discovery that I requested.
Okay, so we're trying to work on discovery issues.
We are, Your Honor. Thank you.
Probable cause conference will be adjourned January 15th, 2026, 9 a.m. Bound continued.
Thank you, Your Honor.
Thank
Thank
you.
you. Court calls case of the People versus Joseph Fonville.
Water Assistant Prosecuting Attorney.
Good morning, Your Honor. Christina Saxon for Joseph Pondville, who's approaching.
Your name, sir?
Joseph Fonville.
Thank you. Okay, what are we doing?
Your Honor, I'm asking for an adjournment as I'm awaiting discovery. I was just pointed to this on Thursday.
During this matter, to January 8th, 2026, 9 a.m. Bound continued. All right, thank you.
Your Honor, may I make a,
I'm sorry?
I was asking for, to make a bond argument, but see.
Oh, okay, he needs to come back up then. Go ahead, briefly.
Your Honor, Mr. Fonville is in jail on retail fraud. From the written discovery that I have, there seems to be some confusion as to whether it was him or not. And I'm asking for a nominal bond on being that it was a non-assaultive offense.
People would object. The confusion around whether it's him or not was because he's allegedly been using his brother's name while he was committing this string of retail frauds. There is an additional retail fraud charge that I am reviewing right now. In fact, I was just given the video for that moments ago that I'll be reviewing. It looks like him and another brother of his continually go in and out of different stores in the area and steal whatever they want. Mr. Fonville has an incredibly long criminal history with dozens of retail frauds dating back decades, in addition to long stints in prison for other theft crimes. He's held on a multitude, at least he was held on a multitude of cases. I don't have ex-jail, so I can't make that representation accurately at this moment, but the people would object.
Motion for bond reduction denied. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case, People versus Dion Baldwin.
Kenneth Overwater, Assistant Prosecuting Attorney for the people.
Where are they? Oh, he's coming out.
And good morning, Your Honor. Assistant Public Defender Ben Dunaway on behalf of Mr. Baldwin, who stands to my right.
Your name, sir?
Mr. Dion Baldwin.
All right, you're seeking a forensic evaluation? Or,
Yes, Your Honor.
If I may.
well, hold on a second. Actually, did you get a report?
No, I submitted the referral form to the clerk of the court by email yesterday. He's not yet been.
Order for an evaluation, right, I see that, okay, I'm sorry, got it. All right,
If I may speak, Judge.
you wanted to say something, what do you want to say?
Yes, I wanted to relieve my public defender yesterday when he came to visit me. He just was incoherent with what I was saying. I wanted to proceed with a preliminary examination with 3 people to show for their side, Nicole Jones, Robert Jones, and Booker T. Jones.
What do you mean he was incoherent? You couldn't understand him?
Yeah, he didn't seem to be understanding what I was saying. He was
Oh,
asking me if I was the owner of the home. I was telling him no. I was applying for personal rep of the property.
so he was asking you whether or not you had ownership in the home on a home invasion case.
Yes.
What a shock.
My brother was the last to have ownership.
So
And that
it's,
was-
it's not really in your
Excuse me.
interest to discuss any facts of the case with the judge, whether you like me or not. It's not good for you to tell him the facts. It's best for you to be quiet, Mr. Baldwin.
So the 11/6 was the date
So, sir,
of the last rep. Now
that involves a probate proceeding, right?
yeah, so I
And
have
that's why
63.
your attorney was doing the proper thing, just based upon what you're saying, and asking regarding certain things regarding that. I don't need to know the terms of that, but that's just a natural kind of thing. And sometimes, if people don't really know what the probate issue is, it's hard to explain, which may have, and you probably were doing it improperly and not with the proper terms, which is probably why counsel may not have understood exactly what you were saying. It has nothing to do with him. So your motion to try to relieve the public defender's office, if that's your reason, is denied.
No problem.
And I will order the competency evaluation, and I'll set that for March 26, 2026, 9 a.m. Bond continued. Thank you.
Good morning once again, everybody. Welcome to the Courtroom Files Live, episode 200 today. Again, thank you so much for all of your support. I can't believe we made it this far, but we're not stopping. We're going to keep going. Special good morning to those of you watching over on Kick, our newest platform. Had an interaction there already today with Simply Kaylee, so thanks for joining us. Real quick, before we move on, yesterday we talked about this rabbit that we found outside and adopted. Well, it's home with us now. There's a photo on the screen. It is a boy. We've figured that out. And it is named Epizon, which is Greek for survivor. So we thought that fit. We'll call him Epi for short. And he'll spend the next couple of days getting adjusted to his new digs up with Grandma TCF. So thank you again yesterday for everybody for your support. Again, all of the super chats and everything we got yesterday will go to the initial care for this bunny. And if there's anything left, it'll be donated to the Humane Society. So again, thank you so much. Let's get back to Judge.
I'll recall your case. He just dropped off our screen.
Okay.
Okay, thank you, ma'am. Court does call the case of the People versus Mary Barney.
And then on behalf of people,
The public defender Natalie Pate with and on behalf of Ms. Barney, who stands to my right. Please state your name.
Wahoo, thank you for
Mary
gifting a
Barney.
membership.
Thank you, Your Honor. Your Honor should be in receipt of a green sheet. I am requesting an adjournment of both files. I do have a correction to what I wrote in the green sheet, which was correct at the time. Our office has now received discovery in the second case late yesterday afternoon. That being said, we are still requesting an adjournment in order to review it and discuss it with Ms. Barney. Then I do have a very brief request as to bond when appropriate.
Probable cause conference, January 8th, 2026, 9 a.m. Esteban.
Thank you, Your Honor. I did speak to Ms. Zenda regarding this, and I do understand that this request was made at the last court hearing regarding this case. We are requesting that Ms. Barney be released to inpatient substance treatment. The only thing that has changed since this request has been made at the last hearing is that Ms. Barney has now been arraigned on the companion case, and it is my understanding that she is now arraigned and there are no new cases coming, so to speak. Outside of that, Your Honor, I'm just asking if Ms. Barney could be allowed to be released to inpatient treatment.
Response.
Your Honor, I'm gonna object again. The reason I say previously, I just don't think that's inappropriate. At this time, for Ms. Barney, I have concerns about the community. I have concerns about the victims. We've talked with them. They are on board. They're really afraid of Ms. Barney and this escalation in her behavior with violence towards them and their child that was in the home. So I'm just gonna object for the reasons I previously stated at this time.
And the court's going to continue its order. I'm going to deny the request. Her bond will continue. Thank you.
Understood, Your Honor. Thank you.
Court calls the case People versus Michaela Whitfield.
Ashley Feltus for the people.
Good morning, Your Honor. May I please support Todd Kaluzny on behalf of Ms. Whitfield?
Ms. Whitfield, can you state your name, please?
Michaela Whitfield, Your Honor.
Thank you. All right, what are we doing?
Your Honor, we had a probable cause conference on December 11th. We adjourned to today's date for discovery. There were some outstanding videos that I still don't have. I talked to Ms. Feltus yesterday, and she is still looking into getting those videos for me. So we're asking for another probable cause conference.
That's correct. I have reached out to the Michigan State Police. We're looking for a video from an interview room at the post, in addition to one other trooper's videos. We have several videos. We're just looking for a couple more.
Got it. Okay, you think you can get that to them? And if I set this for the 15th,
I hope so, Your Honor.
All right. Probable cause conference will be adjourned January 15th, 2026, 9 a.m.
Thank you, Your Honor.
All right, Bond, we'll continue. Thank you.
Thank you.
Thank you, Ms. Whitfield.
Thank you.
Court calls the case People versus Kurt Bushland.
Ashley Feltus for the people.
Morning, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Bushline, who approaches the podium.
Kurt James Bushline.
All right, you're seeking another adjournment.
Your Honor, we're trying to contact Gratiot County, and I'm just having a little more difficulty than I thought I would. So if we could possibly put it over to the 15th, we're trying to get a universal kind of settlement.
You want the 15th?
Please.
All right. That objection, probable cause conference, January 15th, 2026, 9 a.m. Bond.
Thank you.
Thank you, Your Honor.
Thank you. Court calls case People versus Dylan Marshall.
Ashley Feltus for the people.
Good morning, Your Honor. John Dakmack appearing on behalf of Mr. Dylan Marshall. We consent to these virtual proceedings. Mr. Marshall is in the state of New York at this time.
All right. Mr. Marshall, can you state your name, please?
Yes, Your Honor. Dylan Marshall.
Thank you, sir. All right, what are we doing?
Your Honor, the government has offered us a plea resolution. We've accepted that. Your Honor should have written
I do.
copies of those. We're ready to proceed with the plea hearing.
Plea agreement in front of me without a blue tag. Just saying. That indicates that the defendant will be pleading guilty to an added count 2 of larceny, 200 to 1,000. That the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There's a sentence agreement of under 771.1 treatment, whereupon if successful, term of not more than 12 months of compliance, the case would be dismissed. I see. All right. That's the court's full understanding of the agreement.
Yes, Your Honor.
Is that correct, counsel?
Yes, Your Honor.
Mr. Marshall, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
Again, state your name for the record, sir.
Dylan Marshall.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of larceny 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $2,000, that becomes the maximum fine. You understand that, sir?
I do.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo or her successor in the 15th District Court. Do you understand that?
I do.
All right. And understanding all of that, you still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I do.
You signed an advice of rights form or had one caused it to be signed on your behalf. Is that correct, sir?
I believe so, yes.
All right. You recall signing a form of advice of rights?
I do.
All right. Do you have any question regarding any of those rights?
I do not.
And you understand that by pleading guilty, you'll be waiving or giving up those rights.
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
For this, yes. For anything else, no.
Mr. Marshall, you're not on probation yet. Are you
Oh,
on probation or parole
fantastic.
right now for any other offense?
I am not.
Sorry, Your Honor.
I
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily and of your own free will?
I am.
And also because you believe that you're guilty of this offense?
I do.
On September 9th, 2024, at the location of 1200 South State Street, City of Ann Arbor, Washington County, State of Michigan, what did you do that makes you think that you're guilty?
I stole a Michigan football helmet and a national championship baseball hat.
All right. And that was from Schembechler Hall?
It was.
All right. And you had no property interest. Those items that you took didn't belong to you. Is that correct?
That is correct.
And you didn't have anybody's permission to take that property, did you?
I did not.
Do you believe that the value of the property that you took was in excess of $200?
Yes.
All right. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, the court would, first of all, not be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
I do.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. The pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
January 20th at 9 a.m. before Judge Bello.
January 20th, 2026, 9 a.m. Scheduled before Judge Valvo or her successor. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Mr. Young and Mr. Boutwell, I'm seeing you at the same time because your cases are essentially identical for first appearance purposes. Each of you are charged with violating the terms of your state probation or community control. And in each case, the circuit judge has signed a no bond warrant. What we're going to do today is get you arraigned. And what that means is I'm going to appoint you an attorney to represent you if you would like to have one appointed so we can get your case moving. Mr. Young, would you like to have an attorney appointed to represent you?
Yes, sir.
Great. Mr. Boutwell, same question.
Yes, sir.
All right, I'm going to appoint the public defender's officer of the 14th Circuit to represent both of you. Listen to Mr. McDaniel, and then we'll see if you have any questions. Mr. McDaniel.
Your Honor, we're going to plead not guilty. Yes, to set this in the January 8th pretrial docket and advise some screen to come by and talk to them prior to that hearing.
January 8th. Mr. Mitchell, anything?
No, Your Honor.
Okay, so Mr. Green will see you before your court date. Mr. Young, do you have any questions?
No, sir.
All right, sir. Wish you the best. Mr. Boutwell, any questions?
No, sir.
Wish you the best, sir. Next case we have is Kim Benson. Mr. Benson, good morning. Mr. Benson, you're here for first appearance, accused of one count of grand theft between $750 and $5,000. Mr. Benson, I know that you're on bond, but I believe this allegedly occurred before you were on bond.
Correct.
I think this.
I'm not sure though. Let me double check that, Mr. Mitchell.
I think from what I saw, I thought it happened after.
Well, this says November 28th. Let's see when it was put on bond in the other case.
It was in October from what I saw.
Oh, really?
Yeah.
Then that's.
No, sir. December. No, sir. December.
Oh, okay.
Yeah, it was after.
I think the original incident may have happened in October where he was put on bond at the beginning of this month.
Okay. All right, so he was not on bond when this happened. That would be 25-551C if it's the other case. That's one involving Lowe's. These cases today all involve Walmart, and it looks like the bond was posted on about December 5th. But there's a misdemeanor too. Let me see if that misdemeanor's one he was arrested on or not. 25583 MM, that may just be a walk-in. Nope, that was a bond, same day. Okay, so Mr. Benson, the good news is that it does not revoke your bond because this allegedly occurred before you were even on bond. The bad news is, obviously, I'm gonna consider all those other cases as part of your bond today. I'm gonna see if the attorneys have any additional information, and then I'm gonna set your bond in these cases here, the case here, because I think you're entitled to one. Mr. McDaniel, anything on behalf of Mr. Benson?
Nothing except the same stuff as last time.
And it looks like Judge Goodman first appeared him last time, so it must have been a weekend when he got that bond set. So, Mr. Benson, you're going to get a little higher bond today. It's just a different judge, different way of viewing things. Plus, I have additional information of additional charges that judge did not have at that time. Mr. Mitchell?
Your Honor, I think he may have, I'm checking CCIS right now. I think he picked up a new charge in Leon County after these original cases happened.
All right. So, Mr. Benson, give us a second look at that. Go ahead, Mr. Mitchell, and check it out if you
A
will.
bond in which, yeah, there's case number 253302 CF out of Leon, larceny obtained mail by fraud, deception, burglary of structure. He just posted a bond yesterday, and I think that's why he's here before us today.
Do you have the complaint to see when that allegedly occurred?
Yes, let me pull that up. At approximately 5:18 a.m. on December 5th, patrol officers responded to a call of two people trying to break into mailboxes nearby.
5:18 a.m. on December 5th, wasn't that when he posted bond in Jackson County?
I think so.
Sarge, what do you show him posting bond in Jackson County? What date?
December 2nd.
December 2nd?
3rd, I'm sorry, December 3rd is the
Okay,
day.
so he allegedly posted bond, or he posted bond on the 3rd, then he got arrested in Leon County for a crime allegedly occurring on December 5th.
Yes.
Okay.
This is.
All right, so let me read that complaint. It appears the judge has already found probable cause, but I want to read the complaint anyway because there's a good chance I'm fixing to revoke your bond in Jackson County. But let's read the complaint first.
That's why I wanted to pray you.
Is this the right thing? Mr. McDaniel, I'm not going to ask you to say anything that's going to hurt your client, but if there's anything you say that may help him, and I'm glad to listen about the date.
I don't know anything about that, so I know he said he got out on the 4th, and he's, I think I'm gonna let him be careful what he says, but whatever he wants to say, I'm gonna let him say it. But I think he said maybe he was in the wrong place, wrong time, but but go ahead, Mr. Benson.
Yeah, I got out on the 4th, and approximately maybe like the person that come pick me up, they was wanted in Leon County. They had 3 priors, and because of the charges that they were wanted for, they kind of swept me up because I was with the person, not that I so much committed it. So I basically it's the wrong time.
So you did get charged in Leon County, correct?
Yes, sir.
And you posted bond over there?
Yes,
you posted
sir.
bond over there?
Yes, sir.
Let me finish reading the complaint. Yeah. The 3 of them went, according to Benson, according to what the police officers say, you told them, the 3 of them went to the north side of Tallahassee per Cody's instructions. That's the other person. Due to Cody saying she had coupons to drop off, Benson admitted to driving through the neighborhood where Cody would reach in the mailboxes and place the coupon into the box. Cody would sometimes grab mail in the boxes as well as place the mail inside the vehicle. Benson claimed not to know what Cody was doing with the mail and that he was only driving. Benson could not say if Peterson had ever grabbed any mail. I eventually asked Benson about my case. Benson admitted to previously driving Cody to other areas of Tallahassee. That's more than enough there to revoke your bond. I'm revoking your bond in the Jackson County case. So it's going to get confusing because you're entitled to a bond in today's case. That bond in today's case is going to be $25,000 cash or surety. Don't try to post it because I'm revoking the bond that you were on, that you posted a couple of days before you, according to this complaint, you admitted going to Tallahassee and driving someone through a neighborhood while they took mail out of a mailbox. That's items were allegedly used later for some type of theft, or they've been prior thefts used in similar circumstances. So don't try to post a bond, Mr. Benson. I'm revoking your Jackson County bond. Mr. Mitchell, if you give me an order to that effect,
Okay.
I'd appreciate it.
Is it-
You're also going to get a notice for your court date, which will be December 6th in Jackson County at 8:30, but you're going to be in custody, so you'll be seeing the judge on that day. Mr. Mitchell, question?
January 6th.
January 6th, I apologize.
Is-
January 6th, Mr.
Is
Mitchell.
that for both cases, the felony and the misdemeanor?
Yes.
Okay.
Because both of them were on bond December. The bond was filed with the clerk December 5th, but he was posted like December 2nd or
I
3rd.
gotcha.
But it wasn't filed with the clerk till the 5th. That's when the bondsman got it there. The jail got it to the clerk's office. So, Mr. Benson, don't try to post bond right now. There's certainly sufficient evidence that you've committed a new crime after you were on bond, so you're not going anywhere, at least for the time being, sir. Any questions?
25,000.
He was originally on that arraignment docket for the 5th. I think we can move into the jail docket, given that. Okay.
Mr. Mitchell, I didn't see that new charge.
I just caught it today too. I was looking on there, see if there was something else.
Thank you, Your Honor. All right, wish you the best, sir. Next case is Kimberly Broxton. Broxton, good morning. Ms. Broxton, you're here for first appearance, bless you. You've been accused of one count of possession of methamphetamine, possession of drug paraphernalia, a driving license suspended, and the fourth charge is smuggling contraband into a prison or jail. Ms. Broxton, there is probable cause for these charges. I looked at your criminal history, ma'am. I know that you got out of prison, I think, in 24. I think you're entitled to a bond as far as I can tell. Ms. Broxton, I do have a question. The jail sheet says that you are currently on probation. I don't want to, normally I'm going to increase the bond for someone that's on probation, but I can't find that. I don't know if that's accurate or not.
I'm not on probation.
Okay, I did. It's okay. That helps. That's going to get you a regular bond instead of an enhanced bond. So I wanted to make sure. So thank you for letting me know that. I'm going to listen to the attorneys and see if they have any additional information before I decide what bond to set. Mr. McDaniel, anything on Ms. Broxton's behalf?
Nothing, Your Honor.
Mr. Mitchell?
We just request random UAs.
Okay. So Ms. Broxton, since you're not on probation, you're going to get the normal bond for individuals that don't get a conditional release. You're not going to get a conditional release with your history. The methamphetamine is a felony charge and the contraband are felony charge too. Both of those are felonies. So they're going to have a $5,000 bond each. The other two charges are misdemeanors, paraphernalia, and driving while license suspended. They'll have a $2,500 bond each. When you add those four together, you get a total bond of $15,000. Ms. Broxton, that's cash or surety, ma'am, and you've got a condition of random urinalysis. That means that you very well may be drug tested, and if you test positive for something you don't have a legal prescription for, ma'am, that could violate your bond. So you'll get a chance to use the phone in a few minutes, Ms. Broxton. If you post the bond, you'll be released. Ma'am, if you're not able to post the bond, then what's going to happen is the public defender's office is going to see you at the jail. You will be on the January 6th arraignment docket to see Judge Garcia, and we'll see if the state has made a charging decision by that point. Ms. Broxton, do you have any questions?
I just had the drugs that were in.
You have questions about the bond? Nothing else, Your Honor.
Okay, thank you.
All right, ma'am, wish you the best. Next case is Russell Phillips. Mr. Phillips, good morning. Mr. Phillips, you've been here accused of one count of possession of methamphetamine, one count of possession of marijuana less than 20 grams, and one count of possession of drug paraphernalia. I've read the complaint. In your case, there does appear to be probable cause for those 3 charges. And I've also looked at your criminal history, Mr. Phillips. As far as I can tell, you're entitled to a bond. Let me make sure the attorneys don't have any additional information before I set that bond. Mr. McDaniel, anything on behalf of Mr. Phillips?
No, Your Honor.
Mr. Mitchell?
The same condition of random UAs.
Mr. Phillips, I'm going to set you the same bond I would set for Ms. Broxton and the other individuals that got some criminal history, but not on probation. Sir, your methamphetamine charge will be $2,500. Excuse me, the methamphetamine is a felony. It'd be $5,000. The other 2 charges are misdemeanors. There'll be a $2,500 bond each. Mr. Phillips, your total bond is $10,000 cash or surety. You do have a condition of random urinalysis on that bond, which means, sir, that you could be drug tested at any time. So be aware of that possibility. Mr. Phillips, you'll get to use the phone in a few minutes, sir, to try to post the bond. If you post it, you're out of there immediately. If you're not able to post it, then the public defender's office will be in contact with you. Your court date will be January 6th at 8:30 a.m. Central Time. Mr. Phillips, do you have any questions?
No, sir.
All right, sir. I wish you the best. I believe the last case we have this morning is Gregory McIntosh. Mr. McIntosh, good morning, sir. Mr. McIntosh, you're here because you've been accused of 1 count of driving under the influence. Mr. McIntosh, there is probable cause for the charge. When I looked at your driving record, sir, it appears that this may actually be a felony charge. It appears you have 3 prior DUIs. Now, having said that, I think the most recent one is about 20 years ago, and the other 2 are even older than that. So I think you're entitled to a bond. Those are obviously factors for me to consider. So let me see if the attorneys have any additional information before I set you a bond today. Mr. McDaniel, anything?
Nothing else, Your Honor.
Mr. Mitchell?
We just request that as a condition of his bond that he not possess or consume any alcoholic beverages.
Mr. McIntosh, I'm going to set your bond at $5,000 cash or surety because it appears you technically qualify for a felony charge. You have a condition of no alcohol. As part of that bond, you can't possess or consume alcohol.
Yes, sir.
And based upon the breathalyzer, you're also going to have a condition not to drive a motor vehicle. Now, Mr. McIntosh, if you can get a work permit, you can come back to court and I'll consider that, or Judge Garcia will consider it if this goes to felony court. But right now, no driving because appears to be your 4th DUI, even though the others are older, and we'll see what the state's going to do. So it's going to get complicated. So let me try to explain. Mr. Mitchell's office has to make a decision. When they look at your driving record and your criminal history, they either got to send it to felony court and charge it with felony DUI, or Mr. Mitchell may decide to leave it in misdemeanor court. That'll be his decision. The court date I'm about to give you is if it stays in misdemeanor court. If it goes to felony court, this court date will change. But right now, the officer is charged with a misdemeanor. So I'm going to ask the jail to give you a notice for the misdemeanor case date, which will be January 5th.
I think
February.
We're already past the cutoff. Okay.
Yeah.
So, wow, that's going to be really confusing. I'm not going to give you a court date today. Mr. Mitchell, is it too early? I'm assuming it's too early for y'all to know which way you're going to go without looking at the full criminal history.
Yeah, we got to look at the full criminal history.
I'm not going to give you a court date because I don't want you to get confused. You're going to get a notice in the mail to make sure that we're going to check your address in just a second. Make sure you show up at court on whatever date you get the notice in. I'm afraid if I give you a court date in February and then they do take it to felony court and you get a court date in January, it's just going to be confusing. So, Mr. McIntosh, we've got a 7546 address out of Sneed's.
Yes,
I'm
sir.
not going to put your full address on the record, but is that the right numbers?
Yes, sir.
Okay, so make sure you stay up with your mail. It's probably going to be February it's probably going to be February 2nd, but it could be February 3rd, depending on what the state decides. You will get to use the phone in a few minutes, sir, to try to post the bond. And if you post the bond, you'll be released. Just remember, Mr. McIntosh, no alcohol and no driving. If you get your driving license straightened out, come back to court and you can request we'll see what they give you. If they give you a work permit, obviously I'll consider that. I don't think they're going to give you a work permit on the 4th DUI. That's why I'm saying no driving at all based upon the breathalyzer. Mr. McIntosh, do you have any questions?
No, sir.
All right, sir. I wish you the best.
Let's change it up. Let's go up to Lake County, Ohio, Judge Culotta.
R 1421. The defendant is present with counsel Michael Goldberg. A 6-count indictment was filed in this case on October 8, 2025. Counts 1, 2, and 3 are illegal use of a minor or impaired person in nudity-oriented material or performance, felonies of the 2nd degree, in violation of Revised Code 2907.323A1 with forfeiture specifications. Counts 4, 5, and 6 are voyeurism, felonies of the 5th degree, in violation of Revised Code 2907.08C. The state has offered for the defendant to plead guilty to counts 3, 4, and 5 with the forfeiture specification to count 3. It is the state's understanding that today the defendant would like to withdraw his previously entered pleas of not guilty and plead guilty to these 3 counts. It is the state's understanding that the defendant will also voluntarily forfeit an additional cell phone and Android that is not included in the forfeiture specification, and there is no agreement as to sentencing.
Mr. Goldberg, does that sound accurate?
It does, Your Honor. I'll just also state for the record that I've had a chance to meet with Ms. Gold on a couple of occasions. I've reviewed all the evidence, both that she could provide to me in the regular channel of discovery and that was of a more sensitive, privileged nature. I've discussed everything with my client, and he understands his constitutional statutory rights. He understands the benefits of this plea and the potential penalties, and he will make a knowing and voluntary plea here this morning.
Thank you. Ms. Gold, it's my understanding that the victim would like to be addressed to court. Is that accurate?
Yes, Your Honor.
We'll hear from them at this time. So whoever it is that wanted to address the court, state your full name, please, so we know who's speaking, and you can say whatever you'd like me to know.
My name is Giovanna Priola.
What is it?
Giovanna Priola.
Can you spell your last name?
Priola.
Thank you.
Your Honor, I feel the plea deal is too lenient because most days I still have trouble showering and most nights I still have issues sleeping along with nightmares even 6 months later. I feel due to the overwhelming amount of evidence, it should go to trial and the defendant should be held responsible for all 3 counts on both charges. I feel there's absolutely no reason to drop any charges or lessen them because what the defendant did completely changed my life and cannot be undone.
All right, thank you. Mr. Jefferson, were you able to hear what the prosecutor said earlier here this morning, as well as what your attorney just said?
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty and plead guilty to count 3, 4, and 5. And I'll go over those charges with you. Remaining counts will get dismissed. We would defer sentencing to get some reports and evaluations completed, come back on a future day for sentencing. Where there's no agreement between the parties regarding any recommendations, each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, Your Honor.
Well, before I can accept your guilty plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you had that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. At any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
Let's get started then. How old are you?
33.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, I do not.
Are you a U.S. citizen?
Yes.
Now, before you came to court here this morning, have you any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
Nothing.
Now, you should have been served, you would have been served with a copy of this indictment. It looks like you got it sometime back about the second week of October. Do you remember that, this document that sets forth the charges?
Yes, I do.
Did you have a chance at some point to look that over?
Yes.
Now, in this indictment, you're charged with 6 counts. You're pleading guilty to 3 of those. Count 3 The first count you're pleading guilty to alleges, and what you'll be admitting to, is on or about May 23rd, 2025 in Wycliffe Lake County, Ohio, that you did photograph a minor who is not your child or ward. You did that, photographed them in a state of nudity, or you created, directed, produced, or transferred any material or performance that shows the minor in a state of nudity. That conduct constitutes the offense of illegal use of a minor in a nudity-oriented material performance. It's a felony of the second degree. Do you understand what you're charged with and pleading guilty to in regards to count 3?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Charge also carries with it a forfeiture specification, which alleges during the commission of the offense that you had in your possession a black Samsung phone which was used as an instrumentality. An instrumentality is some type of property that's used to facilitate the commission of an offense. Here it's alleged you used this black Samsung phone to commit or facilitate the commission of the offense I just read to you. The purpose of the specification is that at the time of sentencing, any right, title, or interest you have in that property will be forfeited to the state of Ohio. Do you understand that?
Yes, Your Honor.
For the purpose of them disposing of it and getting rid of it. Any questions then about count 3 with the forfeiture specification?
No, Your Honor.
And count 4 is the next charge you're pleading guilty to. Counts 4 and 5 actually, they're the same charge, just different dates. Count 4 is alleged to have occurred on May 17th, 2025. Count 5, the conduct is alleged to have occurred on May 22nd, 2025. And in both of those counts, it's alleged that in Wycliffe Lake County, Ohio, that you did knowingly commit trespass or otherwise secretly or surreptitiously videotape, film, photograph, or otherwise record a minor with initials of GP in a place where a person has a reasonable expectation of privacy, and you did it for the purpose of viewing the private areas of the minor. That conduct constitutes the offense of voyeurism. It's a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to counts 4 and 5?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, there are 3 other charges in the indictment that are being dismissed pursuant to the agreement. Is that your understanding?
Yes, Your Honor.
Any questions about any of those 3 charges?
No, Your Honor.
Well, then before I can accept your guilty plea to the 3 charges I just read to you, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have a right to a trial. Trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also do have a constitutional right to have a jury trial. A jury trial will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence. Then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be a unanimous decision, which means all 3 jurors would have to agree together, one way or the other, whether you're guilty or not guilty of these charges. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty or giving up your right
yes.
to have a trial in this case?
Yes, Your Honor.
And if we had a trial, you'd have the right to have an attorney represent you at the trial. If you cannot afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
Yes, Your Honor.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility, first the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all these charges. That presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when we speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. That's the highest burden of proof there is in our justice system. And what it means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of those charges I just read to you beyond any reasonable doubt before you could ever be found guilty of any of those charges at a trial. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, Your Honor.
Now, in order to do that, or at least try to do that if we had a trial, the prosecutor would be bringing witnesses to come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty or giving up your right to cross-examine or confront those witnesses that would come in here and testify against you at trial?
Yes, Your Honor.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you're not required to do that. You don't have to do that. But you have a right to do that if you want to. Do you understand that?
Yes, Your Honor.
And you further can request the court to issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
You realize you're giving up that right?
Yes, Your Honor.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that is your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
You further understand that if you went to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up any right you have to appeal a guilty finding that I will enter if I accept your plea, as well as any other issues that you could have raised or brought to my attention that could be raised in the future. You're giving up all those. Do you understand that?
Yes.
Well, not any sentencing issues, but any rights, any issues you could have raised up to this time. That's what I meant to say. You understand that?
Yes, Your Honor.
All right. Well, do you have any questions at all then regarding these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No questions,
Do
Your
you
Honor.
understand them all?
Yes.
Do you still want to plead guilty?
Yes, Your Honor.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty in count 3 to a felony of the second degree. This offense is what we call a qualifying offense, and it's simply called a qualifying offense because it was committed after March 22nd of 2019. After that date, all felonies of the first or second degree are subject to indefinite sentencing. Indefinite sentencing means that a minimum sentence and a maximum sentence will be imposed if a prison sentence is imposed. In this particular matter, if a prison sentence was imposed, I would select a number in the range of 2 to 8, 2, 3, 4, 5, 6, 7, 8. And that number, whichever number I selected, would be the minimum sentence you would have to serve. You understand that?
Yes, Your Honor.
Now, in order to determine the maximum sentence, it's simply a mathematical formula. You take half of whatever the minimum sentence is I select, you add that half to the minimum sentence, that becomes the maximum. So I'm going to give you a few examples just to make sure we understand. If I selected 2 years as the minimum sentence, half of that is 1. You'd add the 1 to the 2, your maximum is 3. So it would be an indefinite sentence of 2 to a maximum of 3 years. If I selected 6 as the minimum, half of that is 3. You'd add that to the 6, the maximum would be 9. So it would be an indefinite sentence of minimum of 6, maximum of 9. And likewise, if I selected 8, which would be the maximum for the minimum sentence, half of that is 4. You'd add that to the 8. Your maximum would be 12. So it would be the maximum sentence you face on count 3 is an indefinite prison term of a minimum of 8 years, maximum of 12 years. Do you understand that?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Now, the other remaining counts, I think they're 4 and 5. Is that correct?
Yes, Your Honor.
4 and 5 are felonies of the 5th degree. Those are each punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range. So if I impose the prison sentence, I'd select one of those numbers, 6 through 12, and that'd be the number of months you'd have to serve for that particular count. Do you understand that?
Yes, Your Honor.
Now, since there are 3 separate offenses here, if I impose a prison sentence, I would impose it on each count in the manner that I just described. And then as the judge, I had the discretion to run those prison terms either concurrent or consecutive to each other. Concurrent means together. You'd serve them at the same time. Consecutive means one after the other. So you'd serve, if all three were consecutive, you'd serve the prison terms on the felonies of the 5th degree first, whatever those were. Then you'd serve, after you completed that, the indefinite sentence on count 3. You understand that?
Yes, Your Honor.
So in this particular case, if I impose the maximum sentence on each count, the 8 to 12 plus 12 plus 12, 8 to 12 years plus 12 months plus 12 months, the maximum sentence you face in this case is an indefinite prison term of a minimum of 10 years, maximum of 14 years in prison. You understand that?
Yes, Your Honor.
Now, are you currently on probation or parole or any type of supervision in any of the courts or agencies?
I am on GPS ankle monitoring.
That's for this case, though, right?
Yes.
So that's a bond condition. I'm talking about for other cases that may have occurred previously.
No.
So you're not on probation to another court for any other prior case or
No, Your
release
Honor.
control or anything like that? Do you have any other charges pending against you anywhere else?
No.
If a prison sentence is imposed in this case, upon your release from prison, you would be placed on what is called post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after you completed whatever the prison sentence was. And in this particular case, it would be 5 years. It would be mandatory, and it'd be 5 years. Do you understand that?
Yes, Your Honor.
And if you were on post-release control and you ever violated any of the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could order more restrictive sanctions against you, that you serve more restrictive sanctions, including local jail time. Or I could terminate or end your probation at that point and send you to prison then. If I did it at that point, again, it could be for that period of time I told you before, up to a maximum of indefinite term of 10, maximum of 14 years. Do you understand that?
Yes, Your Honor.
That would also be, or could also be, consecutive to any other prison sentence you may be serving for some other case if something else happened, or that you're being sentenced to at that time if something new happened. You understand that?
Yes, Your Honor.
Now, in regards to the indefinite sentence that I just explained to you for count 3, there's some other things I need to tell you about that. In terms of that minimum sentence, whatever the minimum sentence is that is imposed by the court, there is a presumption, a rebuttable presumption, I'll explain what that means, that you be released after you've served that period of time for the minimum sentence. Now, that's not guaranteed, but there's a presumption that you should be released. That presumption, however, could be overcome if the Department of Rehabilitation and Corrections, the prison system, is able to establish at a hearing that while you were confined, you violated rules of the institution, prison rules. You weren't sufficiently rehabilitated. You were a threat to the community. If anything like that was present, they would have a hearing. And if they were able to, which you'd be present at, have a right to be present at least. If they were able to establish that at the hearing, then you wouldn't be released at the minimum sentence. You would remain in prison. They would select a new date that you could be, that you would be released, and that new date would be a presumption that you'd be released at that time. But the same procedure could be followed. Again, it's not guaranteed. If at a hearing they established that you still were committing violations of the rules, you were a threat, you weren't sufficiently rehabilitated, they can keep you in prison again. However, under no circumstances can they keep you in beyond the maximum sentence. So hypothetically, if I gave you the maximum sentence, 14 years, they'd have to release you at that 14 years, even if you misbehaved every day you were there. They'd have to release you at that point. You understand that?
Yes, Your Honor.
Also, if I did impose a prison sentence, you would have the ability to earn what is called good time credit, which could reduce the period of time that you serve and sentence, and that's done by participating in programs, et cetera, while you're in prison. Now, again, that's not guaranteed, but you would have the right to earn anywhere between 5 to 15% credit off your sentence. In terms of that the first issue I was explaining to you about the getting out at the minimum sentence, I have no say in that. I have nothing to do with that. In regards to this good time credit, if you did earn good time credit, there's a presumption that you should get it, but it's not guaranteed again. And in that regard, the prison officials would notify me or whoever's sitting here at that time in this seat, and it'd be up to the judge. If the judge wanted to not approve it, he would have or she would have a hearing, which you would be present at. And after that hearing, the judge could approve or disapprove of that credit. If there's no hearing, though, it has to be approved. You understand that?
Yes, Your Honor.
Now, in addition to the possible prison sentences that I just explained and the circumstances all about that, there's other sanctions that could be ordered. You could be fined in this case. Count 3, the felony in the second degree carries with it a possible fine of up to $15,000. The other 2 charges carry a possible fine of $2,500 each, so altogether is a maximum fine of $20,000. Do you understand that?
Yes, sir.
You could also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment, if any that were applicable. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay restitution to the victim for an economic loss the victim may have suffered as a result of the conduct involved. Do you understand that?
Yes, Your Honor.
Also, in regards to the forfeiture specification, at the time of sentencing, you'll be ordered to forfeit the property that is described in that specification, and apparently there's also some agreement between the parties regarding another phone that's going to be forfeited at the time of sentencing. Do you understand that?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Lastly, since you are pleading guilty to a sexually oriented offense, at the time of sentencing, you will be advised by the court of what your obligations will be to register as a sex offender. You'll be required to, you'll be classified as a Tier 2 sex offender, correct? Tier 2?
Yes, Your Honor.
Tier 2 sex offender, and you will be required to register in person at the sheriff, the county sheriff, for the county where you reside, and then also where you work or go to school if that's applicable, if it's a different county. Do you understand that?
Yes, Your Honor.
And you'll be required to do that. I'm going to explain this in more detail at the time of sentencing, but it'll be every 180 days for 25 years. Do you understand that?
Yes,
Which
Your
would
Honor.
start after any incarceration, if any incarceration is imposed. Do you understand that?
Yes, Your Honor.
And again, you'll get more specific details about that. I just need to make sure at this point you understand that that's a consequence of and something that's going to happen as a result of pleading guilty here. You understand that?
Yes, Your Honor.
Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible. Prison is not mandatory with any of these charges. With each of these charges, you are eligible for probation, what's called community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means it'll be considered if that's what you're asking for. But I'll look at all the information presented and I'll make the decision I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Now, while you are eligible for community control sanctions, I need to advise you that count 3, the felony of the second degree, carries with it a presumption for prison, which means there is a presumption that the court would have to impose a prison term unless certain findings could be made by the court to overcome that presumption and allow me to put you on community control sanctions. Do you understand that?
Yes, Your Honor.
Now, if you are put on community control sanctions, it could be for up to 5 years, and as the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. Do you understand that?
Yes, Your Honor.
Further, if you are on probation, you violate any of the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could order more restrictive sanctions against you, including an order that you serve time in our Lake County Jail, or I could terminate your probation and send you to prison at that point. And if I did it at that point, again, it would be for the same period of time, or it could be for the same period of time that I explained earlier. up to a maximum of an indefinite prison term of a minimum of 10 years, maximum of 14 years, which can also be consecutive to any other prison sentence that you may be serving for something else at that time or you're being sentenced to. Do you understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you're going to have the right at that time to say anything you want, anything you'd like me to know or consider. Your lawyer can speak on your behalf. He can recommend the sentence to court. Prosecutor has a right to recommend the sentence to court. The victim has a right to speak at sentencing. Do you understand that?
Yes, Your Honor.
Do you understand that whatever anyone says at sentencing regarding what the sentence should be, it is just what I said. It's a recommendation. I don't have to follow any of the recommendations. Even if it's agreed to, I don't have to follow it. If I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right. Do you have any questions for me about the potential penalties you face by pleading guilty?
No, Your Honor. No
Understand all the
questions.
possible consequences?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to discuss this case with your lawyer and have him review everything with you, go over the reports, answer your questions?
Yes, Your Honor.
Are you satisfied with the advice and counsel of your lawyer?
Yes, Your Honor.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here today?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering the guilty plea freely and voluntarily?
Yes, Your Honor.
All right, then, do you have any questions for me at this point regarding anything we've just talked about, regarding the rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all for me?
No, Your Honor.
Do you need any more time to speak to your lawyer before we go forward with the actual plea?
No, Your Honor.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me, excuse me, what she believes the evidence would show if we had a trial. I want you to listen to her because then I got some follow-up questions for you about that, all right?
Yes, Your Honor.
Ms. Gold for the state.
Thank you, Your Honor. The facts would show that during the time frame in the indictment, the defendant was living with his ex-girlfriend Angela Priola and Miss Priola's 16-year-old daughter, minor victim GP. They resided at a house in Wickliffe, Lake County, Ohio. On May 17th, 2025, May 22nd, 2025, and May 23rd, 2025, the defendant set up his Samsung phone in the bathroom of the home where minor victim GP had a reasonable expectation of privacy to secretly record her. On each date, the defendant recorded video of minor victim GP going to the bathroom and or showering while she was in a state of nudity to view her private areas.
Mr. Jefferson, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial?
Yes, Your Honor.
What, if anything, do you have to say about those facts as they were just presented? Are they true? Did you do what she said?
They are true, Your Honor.
Very well, then, regarding count 3, charging with illegal use of a minor in a nudity-oriented material or performance, a felony of the 2nd degree, what is your plea to that count?
Guilty.
What about the forfeiture specification regarding the use of the phone as an instrumentality? What is your plea to that?
Guilty.
As to counts 4 and 5, each charging with voyeurism, each felony is of the 5th degree, occurring on different days. What is your plea to each of those 2 counts?
Guilty.
All right, this time I have in my possession here a document called a written plea of guilty and judgment entry, which sets forth and explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document, what it says, and that you sign it here in open court. Excuse me. Now, my understanding is that before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Goldberg, is that accurate? Did you review this with Mr. Jefferson, read it over to him, and answer his questions?
That is accurate, and I did do so, Your Honor.
And did he indicate an understanding of that to you when you did that?
Yes, he did.
Is that correct, Mr. Jefferson?
Yes, Your Honor.
So you understand what the document says?
Yes, Your Honor.
Any questions for me?
No questions.
It also appears that you signed the document a couple times. Did you in fact sign it?
Yes, I did.
You witnessed that, Mr. Goldberg?
Yes, Your Honor.
Ms. Gold, you as well?
Yes, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, illegal use of a minor in a nudity-oriented material or performance, felony of the second degree in violation of 2907.323A1 with the forfeiture specification, as well as counts 4 and 5, voyeurism, each felonies of the fifth degree and each in violation of 2907.08C. The remaining counts will get dismissed at sentencing, but I'm going to defer sentencing, order a pre-sentence report investigation, victim impact statements. Anything else you're requesting report-wise, Mr. Goldberg?
No, Your Honor.
As for bond, where were you this morning, Mr. Jefferson? You're supposed to be here at 9 o'clock for this sentencing. We had to sit around and wait for you to get here.
I apologize. I was not made aware of the time, just the date, and that is my fault. I was on my way to help.
You were made aware of just the date, so we're going to show up at 3 this afternoon, 6 o'clock tonight?
No,
So if you didn't know a time, you knew a date, why wouldn't you make some attempt to find out what that time was, or be here at midnight so you make sure you're here for sure?
That was a lack of responsibility on my part.
I don't get it. You weren't told the time by who? Your lawyer, I guess you're saying?
Correct.
So why wouldn't you, when did you find out when the hearing was?
A few days ago. I had the dates wrong. I thought it was tomorrow. I thought tomorrow was the 23rd. I was incorrect.
It's the second time this has happened. No, these are serious charges here. I mean, we think you take it serious.
I do, absolutely.
You know.
Can I speak to this, Your Honor?
Sure.
So this was originally scheduled for the 19th to accommodate the state and the victim. It was moved to today. I did inform my client it was moved to the 23rd. He asked what time. I said it's going to be early. That's before I had the time. I never corresponded with him. Obviously, it's his responsibility to be here on time. When I called him this morning, he was indicating to me that he thought it was tomorrow. And he turned around and got here as quickly as he could. And so that's what happened. And, you know, to the extent that I didn't give him the exact time, that's my fault, but we know that it's ultimately.
Yeah, but if he gets a date and he has a court date and doesn't have a time, the first thing he should be doing is getting on the phone saying, what time is this hearing? When were you going to show up? So even if you thought it was tomorrow, when were you going to show up tomorrow?
I was going to reach out to my attorney today and ask for a time.
Well, again, if you're taking it seriously, you would have done it the day you got the notice instead of waiting till a day before to do it.
I would just state, Your Honor, that he's taken this very seriously. He's agreed to a forfeiture that's outside of the indictment. He's shown up at my office every single time, and this is, I believe, even though it's comes on a very serious matter, he made an honest mistake.
Now, will the court will continue defendant's bond and order of cognizance with an order that the defendant have no contact with the victim or the victim's family, and follow all terms and conditions of the protection order. So, Mr. Jefferson, the matter is being referred to the probation department for reason that's going there so they can prepare a pre-sentence investigation. The way they get the information they need to prepare this report is they're going to conduct an interview with you. It's important that you show up on the right day, at the right time, for the purpose of that interview. Because if you don't show up, then they're not able to, and they don't have an interview, they're not able to do a report. And without a report, I'm not even able to consider probation as an option. So if you don't know when it is, if you don't know the time, it's your responsibility to find that out. If you think it's the next day and you don't show up, you're out of luck. So you better be damn well sure you know what date it is and you show up at that time. It's also important that you're open and honest with them when you meet with them, because they're going to check and verify everything you tell them. And if they learn you're misleading them in any way, they'll let me know. And I certainly would consider that as sentencing. You understand that?
Yes, Your Honor.
So you're going to leave here now. You're going to go over to the probation department. You're going to fill out some initial paperwork. Then you're going to get a date to come back for the interview. So make sure you go there when you leave here right now. You know where that is, Mr. Goldberg, right?
Yes, Your Honor.
So your lawyer will bring you over there or tell you where to go. But make sure you go there when you leave here now.
Yes, Your Honor.
Mr. Gold, anything else? Ms. Gold, anything else for the record?
Your Honor, because the defendant is on an OR bond, I would ask if we could put the sentence
Oh, yeah,
date on
I
the
will do
record.
that. When is that, Mr.?
February 9th,
Right.
3 o'clock, sir.
So your sentencing is February 9th at 3 p.m. That's here. So that's what time you need to be here for your next court date. Again, this OR bond means you have to appear at all future court dates, and if you fail to do that, you can be prosecuted for a new felony and get up to 18 months in prison on that, which could be consecutive to anything that happens on the original charges. So it's obviously important to show up at all future court dates. But again, before that February 9th date, you're going to need to go to probation department, so make sure you do that as well.
Yes, sir.
All right. Mr. Goldberg, anything else?
No, Your Honor, thank you.
Thank you.
A sister that he's close to in the Cleveland area. That is how he ended up here from Florida. You know, Mr. Jones has always been, I know he's had some issues in the jail and in his past, but he has always been polite and respectful with me. I know it indicates in the PSR that he didn't really want to do probation or might not show up. He has told me that he absolutely would show up if he was given a community control sanction. I do also think that he could benefit from some sort of mental health treatment and something, you know, maybe some services to help him get himself together out here in the community. Mr. Jones is remorseful that this occurred. I will say that while this is a burglary, a felony of the 3rd degree, it's not really your traditional burglary. It happened in a hotel, and there was one abandoned room that had things in it, and then this was another room that had things in it, but the door didn't quite shut or lock. There was something with the door where it just opened. So it's not like he had to, you know, bust the lock and break in that way or anything like that. He simply just, you know, pushed the door open and walked in. So it is a less serious form of the offense, Your Honor. And I would just ask you to take that into account when imposing a sentence. Thank you, Your Honor.
Thank you. Mr. Jones, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
No, sir.
Ms. Hibbert, anything else?
No, thank you, Your Honor.
Ms. Alessi?
Thank you, Your Honor. Pursuant to the plea agreement in this case, the state did agree to recommend community control sanctions. We felt at that time the defendant could benefit from mental health treatment and drug and alcohol treatment. As of today, the defendant has 106 days of jail time credit, and the victim did not request any restitution here.
This court has considered the pre-sentence report investigation, the psychological evaluation. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. I've considered what's been said here today by Ms. Hibbert, prosecutor. The defendant was given a chance to speak, chose not to make a statement, which is fine. All this is considered by the court. Oh, I also received a victim impact statement, and I've read and taken that into consideration. All this is considered by the purposes and principles of felony sentencing set forth in 29-29-11, which were factors in 29-29-12. Victim suffered psychological and emotional trauma as a result of this conduct. I don't believe anything makes it less serious. This is where the victim was living at the time. You know, it was a hotel. The defendant broke into the place where the victim was living and took his items. So I don't think anything is more or less serious in that regard. For recidivism factors, the defendant has a history of juvenile delinquency adjudications as well as convictions as an adult. He has failed in the past to comply with previously imposed sanctions ordered by courts. He's been on probation before in the past. He's violated his probation multiple times before in the past. There's absolutely no remorse. The defendant denies, first of all, committing the offense, denies taking anything when he met with the probation department. There's been no showing of remorse here. So it wasn't during the pre-PSR, it wasn't here. There's no remorse, let alone any genuine remorse. Defendant has indicated to the probation department that he doesn't want to be on probation. He's not going to report it. He's not going to be able to do it. He doesn't want to do it. These are all factors indicating recidivism is more likely. Nothing makes it less likely. It's a felony of the third degree. There's no presumption either way. Prison is consistent with the purposes and principles of sentencing. There's just no way this court can make any finding that the defendant's amenable. He said himself he's not. Therefore, it's a sentence to this court that the defendant served a term in prison of 12 months. He has credit for 106 days he served. I need to advise you upon your release from prison, you'll be placed on post-release control for at least 1 year. It could be up to 3 years. While on post-release control, if you violate any of the conditions of your post-release control, the parole authority can send you back to prison as punishment for violating their rules for another 6 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, transfer to transitional control. Defendant's ordered the penal costs incurred in this action. Is there anything else for the record, Ms. Alessi?
No, Your Honor, thank you.
Ms. Hibbard?
No, thank you, Your Honor.
All rise.
Fairly short and sweet from Judge Culotta. Things are usually a little more drawn out there. Guess he's in a hurry to get to Christmas. Let's, haven't gone here in a while. Let's go to Lubbock, Texas, and their jail magistrate court.
Ms. Arredondo, you're here today to enter a plea. We're handling your plea over this Zoom proceeding. Is that all right with you for us to handle your plea over this Zoom?
Yes, Your Honor. Yes, Your Honor.
Fingerprints were taken from you there at the facility for us to use as your signature on your paperwork today. Is that okay with you for us to use your fingerprint as your signature?
Yes, Your Honor.
And have you been able to go over all of your paperwork prior to court with your attorney, Ms. Hillstrom?
Yes, Your Honor.
And did you understand everything and sign everything with your fingerprint freely and voluntarily?
Yes, Your Honor.
Now, in the county court 2025 criminal case 2223, you're charged with a Class A misdemeanor offense. And do you understand the full range of punishment that you're facing?
Yes, Your Honor.
And there's been a plea offer that was made to you today. Other than that offer, has anyone promised you anything for you to enter any type of plea today?
No.
And Ms. Hillstrom, do you feel like that your client understands her rights and the proceedings as well as her charges?
Yes, Your Honor.
All right, then Ms. Arredondo, in this county court case ending in 2223, you're charged with a Class A misdemeanor offense of false alarm or report committed back on June 17th of 2025. And how do you plead to that charge?
Guilty.
I will accept your plea of guilty and find that you are guilty of this offense. I will also follow the agreement that you have made today, and I will now assess your punishment in this matter at 60 days in the Lubbock County Detention Center with your court costs of $325. You're going to receive all of the jail credit that you do have in your case towards your sentence. Your jail credit is showing to be a total of 62 days from October 22nd, 2025 to the present time. And does that sound like your correct jail credit?
Yes, Your Honor.
Okay, now your jail time and your court costs are running concurrent with each other as permitted by law. So you are getting jail credit towards those court costs that you're owing. And you're not going to be required to repay the county for any attorney fees as costs of court based on the original indigency finding made when your attorney was appointed to represent you. And then having said all that, that makes this a time served matter in that case. Was that your understanding, ma'am?
Yes, ma'am.
Okay, and then as part of the agreement in your case today, I'm signing a dismissal of County Court 2025 criminal case 2222. And with that dismissal, does that resolve everything that your client has pending at this time to your knowledge, Ms. Hillstrom?
Yes, Judge.
Okay, anything else from the state?
No, Your Honor.
Anything else, Ms. Hillstrom, in this case?
Nothing further, Your Honor.
All right, then Ms. Arredondo, jail staff will get you released later today once they're able to process my paperwork there at the facility. And you are adjourned and may leave the courtroom at this time.
Thank you, Judge. Thank you.
Thank you. Have a happy holiday. Lacey Jordan, you're next. Ms. Jordan, you're here today to enter a plea. We're handling your plea over this Zoom proceeding. Is that okay with you for us to handle your plea over this Zoom?
Yes, Your Honor.
And some fingerprints were taken from you there at the facility for us to use as a signature on your paperwork today. Is that okay with you for us to use your fingerprints as your signatures?
Yes, ma'am.
And have you been able to go over all of your paperwork prior to court with your attorney, Ms. Hillstrom?
Yes, I have.
And did you understand everything and sign everything with your fingerprint freely and voluntarily?
Yes, I did, Your Honor.
Okay. Now in this county court 2025 criminal case 2929, you're charged with a Class A misdemeanor offense. And do you understand the full range of punishment that you're facing?
Yes, ma'am, I do.
And there was the plea offer that was made to you. Other than the offer, has anyone promised you anything in order for you to enter any type of plea today?
No, ma'am, they haven't.
And Ms. Hillstrom, do you feel like that Ms. Jordan understands her rights in the proceedings as well as her charges?
Yes, Your Honor.
All right. Then Ms. Jordan, in this county court case ending in 2929, you're charged with a Class A resisting arrest, search, or transport committed back on November 20th of 2025. And how do you plead to that charge?
Guilty.
I will accept your plea of guilty and find that you are guilty of this offense. I will also follow the agreement that you've made today, and I will now assess your punishment in this matter at 33 days in the Lubbock County Detention Center with your court costs of $280. You're going to receive all of the jail credit that you do have in your case towards your sentence. Your jail credit is showing to be a total of 33 days from November 20th of 2025 to the present time. And does that sound like your correct jail credit?
Yes, ma'am, it does.
Okay, so your jail time and your court costs are running concurrent with each other as permitted by law. So you are getting jail credit towards those court costs, and you're not going to be required to repay the county for any attorney fees as costs of court based on the original indigency finding made when your attorney was appointed to represent you. So having said all that in your case, that means that matter is time served. Is that your understanding?
Yes, ma'am, it is.
Okay. And does this resolve everything that your client has pending at this time to your knowledge, Ms. Hillstrom?
It does, Your Honor.
And is there anything further from the state?
No, Your Honor.
Anything else in this case, Ms. Hillstrom?
Nothing further, Judge.
All right, then we will be adjourned in this matter. Ms. Jordan, jail staff will get you released later today once they're able to process my paperwork there. And you are adjourned from the courtroom. Thank you for your attention.
Yeah.
Shannon Garcia is next. And Ms. Hillstrom, you're adjourned. Have a good holiday.
You too. Merry Christmas, Judge.
Ms. Garcia, you're here today to enter a plea. We're handling your plea over this Zoom proceeding. Is that okay with you for us to handle your plea over this Zoom?
Your Honor.
Some fingerprints were taken from you there at the facility for us to use as your signature on your paperwork today. Is that okay with you for us to use your fingerprints as your signatures?
Yes, ma'am.
And have you been able to go over all of your paperwork prior to court with your attorney, Mr. Lamond?
Yes, Your Honor.
And did you understand everything and sign everything today freely and voluntarily?
Ma'am.
Okay. Now, in this county court 2025 criminal case 2071, you are charged with a Class A assault domestic violence. And do you understand the full range of punishment that you're facing in this case?
Yes, Your Honor.
And there was a plea offer that was made to you. Other than the offer, has anyone promised you anything in order for you to enter any type of plea today?
Amen.
This is an assault domestic violence charge, and if you do plead guilty to this and you are convicted, if you were to commit another assault domestic violence in your future, this state or another state is going to be able to use this conviction from today in any future case of assault domestic violence in order to make the punishment worse on that future crime. It would be used as what's called an enhancement provision. Do you understand that?
Your Honor.
Also this is one of those types of cases that will negatively impact your ability to purchase or possess any firearms, weapons, or ammunition of any kind in the future. And do you understand that as well?
Yes, ma'am.
Okay. And Mr. Lamont, do you feel like that Ms. Garcia understands her rights in the proceedings as well as her charges?
Yes, Your Honor. And in relation to the affirmative finding of family violence, I specifically went down this morning and provided her detailed information along with a summary of that information and answered any questions that she had. So I do believe she is fully informed and ready to move forward.
Okay, great. Thank you. So Ms. Garcia, back to you. In this county court case ending in 2071, you are charged with a Class A assault domestic violence committed back on August 19th of 2025. And how do you plead to that charge?
Guilty, Your Honor.
I will accept your plea of guilty and find that you are guilty of this offense. I will also follow the agreement that you've made today, and I will now assess your punishment in this matter at 119 days in the Lubbock County Detention Center with your court costs of $350. You are going to receive all of the jail credit that you have in your case towards your sentence. That is showing to be a total of 119 days from August 19th through September 18th of 2025, and then September 26th of 2025 to the present time. And does that sound like your correct jail credit?
Yes, ma'am.
Okay. Now your jail time and your court costs are running concurrent with each other as permitted by law. So you are receiving jail credit towards those court costs that you're owing, and you're not going to be required to repay the county for any attorney fees as costs of court based on the original indigency finding made when Mr. Lamond was appointed to represent you. And having said all that, that makes this a time served matter. Was that your understanding, ma'am?
Yes, Your Honor.
Okay. And does this resolve everything that your client has pending here in Lubbock to your knowledge, Mr. Lamond?
Yes, Your Honor.
And is there anything further from the state?
No, Your Honor.
Anything else, Mr. Lamond?
No, Your Honor.
All right, then we will be adjourned in this matter. Ms. Garcia, you're adjourned from the courtroom. Jail staff will get you released later once they're able to process your paperwork there. Have a good holiday.
Thank you, Your Honor.
Thank you. And Mr. Lamond, you're adjourned unless you need something else from the court.
Thank you so much. Have a great day.
Thank
Happy
you.
holidays.
All right, let's switch it up a little bit. Let's go to, why is my phone ringing? Let's go to Judge Oakley. Let's see what's going on with him today.
Have a seat, people.
I knew a guy that was a truck driver, kept going to chiropractor, doing bad guy. He was a chiropractor, fellow told him, quit sitting on your wallet.
Oh, yes.
His wallet was like that thin.
It's like, what an idiot. How come he couldn't figure that out?
Exactly.
He could stop fighting me. Where'd you go?
I thought you had a favorite train. Thomas Markowski. Good morning, Mr. Bowditch.
Good morning, Frank or Jeff about 45367. Hearing on behalf of Tomkowski. Sir, could you tell the judge your name for the record, please?
Good morning.
Your Honor, today's date time set for writing in this matter. We waive formal readings. Also had a chance to pre-try this case, Your Honor. You have an executed plea agreement subject to court approval. In that agreement, Mr. Tomkowski, when you plead guilty to an addict, writing all visibly impaired, understanding the including charge would be dismissed.
Thank you. Sir, did you discuss your rights and options with Mr. Bowdish today? You understand your, those options you're presented with?
Yes.
You understand the possible penalty for the charge?
Yes.
And how do you wish to plead?
Yes.
Are you pleading guilty freely and voluntarily today? Mr. Bowdish, would you voir dire?
Yes.
Morning, Mr. Kaplan.
What are your answers?
Offense date was October 11 this year.
Mr. Markowski, on October 11th of this year, were you driving, sir?
I was.
Were you driving in van here in town?
Yeah.
Had you been drinking?
Earlier, yes.
What had you been drinking? Beer.
Yes.
You believe because of consumption of that alcohol, your ability to drive a vehicle is impaired?
Yeah.
Did you take the breath test, sir?
I did.
Do you have any reason to doubt or challenge the validity of that test?
No.
Your Honor, I don't believe we know that. But, do you believe it was over the legal?
All right.
Yeah.
Defense is satisfied, Your Honor.
So am I. I'll dismiss the original charge.
Thank you.
All right, Mr. Makarowski, I am going to refer you to my probation department downstairs. They're going to schedule with you to come back for an interview and a sentencing date. Based on that interview, they're going to put together a report and a recommendation of sentence. You'll have a chance to go over that with Mr. Bowditch for your sentencing date. I will have read that report, then we'll talk about that report and anything else you want to talk about before I sentence. You understand all that? In the meantime, I'm going to put you on a personal bond. First two conditions are pretty obvious. One, stay out of trouble. Two, cooperate with the process so we can move you towards sentencing. Third condition is do not purchase, possess, or consume any mood-altering substance unless you've got a doctor's prescription. That means marijuana and alcohol are off the table. Understood? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you screw up on bond?
Yeah.
Any questions? You're all set. Go on downstairs. Front counter, they'll call your name, give you those dates. Enrique, you're welcome. Enrique Cano Hernandez.
Right, Your Honor. Thank you, Your Honor, for the record, Jeff. Yeah. Sir, could you tell the name?
Enrique Cano Hernandez.
Good morning, sir.
Your Honor, today is the time set for arraignment in this matter. We wait for the briefing standing. We've also had a chance to pre-try this case, Your Honor. It's 2022 and 2019 case. On both of these matters, Your Honor, we have an executed plea agreement subject to court approval. In both of these matters, Mr. Cano would be pleading guilty to an added count of no operating license on person. Given the understanding, the original charges would be dismissed.
Thank you. Sir, do you understand your rights and options? You understand the possible penalty? Understanding this, are you pleading guilty to two charges, 2 counts of no valid operator's license on person? And are you doing so freely and voluntarily today? On January 7, 2022, did you drive a vehicle in Van Buren Township? Was your license suspended, revoked, or denied at the time? On November 4, 2019, did you drive a vehicle in Van Buren Township?
Yes.
Was your license suspended, revoked, or denied at the time? I'll accept your plea to both added charges, dismiss both the original charges. What's the status now?
Your Honor, he's working on, he has to settle an immigration issue, and then he'll get his CDL back. He has CDL on.
Okay.
Your Honor, the only thing that might come in, and I don't know, he was since 2022. Matter of fact, I think this year, he hasn't been incarcerated.
Since 22?
Yes, since 22. Matter of fact, I think it was this year.
Yes.
And I don't know if the judge would, if his incarceration would matter the length. I think it was 11 days for this one, but he did 4 months. I think between here and Livingston.
Yeah.
Yeah.
How was he in jail on these files?
Here, it was, session on stolen property of the car.
Okay, so you weren't in jail on these charges.
Out of this court, a felony court, yeah.
Understood. All right. Okay. All right. And are you working now? Where at?
Like for myself, self-employed,
What do you do?
uh, construction basically.
What kind?
Everything basically except driveways.
Okay. All right, we've got a speeding ticket from 2019, a registration plate charge from 2022, a no proof of insurance from 2022, $1,200 worth of tickets you've never done anything on. Why not?
Here,
Here.
I was told that's all I had, the driving suspended.
You were told by who?
The judge that I saw for because they put me on diversion.
Okay.
They said you have to take care of these 2 tickets, and that was these 2, and not.
Okay, well, they might have been talking about misdemeanors.
Oh,
Yeah.
With the civil infraction, if you civil, if you also default.
oh,
If it's a misdemeanor, you get a warrant. If it's a civil infraction, they just assume your guilt.
oh. Well, I have to take care of all of them now, no matter.
Are you in a position to do that?
Right this second, no, but I can do it within the next 2 weeks.
All right, so those tickets are $1,281. You can take care of that in 2 weeks?
Yes.
Okay, so by the 9th? All right, that takes care of that pile of money. Anything you want me to consider before I sentence you on today's files? All right, normally on these charges, I would assess fines and costs and 4 days on the court work program, but given the fact that we had you for a while on some other files with jail, I'm going to waive that. You're welcome. All right, unfortunately, because these files are so old and we haven't seen you, you've racked up some late fees and penalties. So on each of these files, fines and costs is $650. I'm going to let you set up some kind of payment plan or payment arrangements downstairs today. So before you get out of here, have a paper plan on how we're going to get our money on those. All right, whether or not that's a due date, you're going to pay it all, or if you're going to do it over payments, however you do it.
Yeah, I didn't know to make payments on first.
Yeah, yep. But before you get out of here, I need that on paper.
Okay.
You're all set.
Thank you.
Thank you, Ron.
You're welcome. Aaron, is it Franchuk? How do you say it? Counsel, your appearance.
Good morning, Your Honor. A piece of sound from the floor. On behalf of the defendant, Aaron Frank, you stand to my right. Please state your name for the record.
My name is Eric Stephen Franklin.
Good morning, gentlemen. Tell me about the plea.
Yes, Your Honor. For the purpose of arraignment, like waive the formal reading to stand mute.
Done.
I did have an opportunity to speak with the prosecutor for purposes. We reached an agreement in this matter, Your Honor.
Go ahead.
To dismiss the original 2 counts, it's going to be in section of civil practice. My client would plead responsible for the double parking.
I see that, and he's agreed to pay fines and costs of $400.
Yes.
All right, I'll do it on the civil infraction, Heather. And can you pay the 400 today?
Okay, next week.
We do 14 days, Your Honor. If that's
Sure.
Thank
All right, both original charges are dismissed.
you.
Hold on, what do we got all here? Except for. All right, you've got something coming up for a review on January 5. Oh, offer sent to attorney on 12/9, must respond by 12/17. Are you handling some civil fractions for us?
Civil fraction.
Yeah, that one I just talked about was a speeding 21 over. And then we got another one. Failed to signal and observe, review set for 12/18/25, still in pending status. Yeah, you might want to check those downstairs so we don't miss a deadline.
Absolutely.
All right, have a good day, gentlemen.
Thank you.
You as well.
Thank you.
What's this pile up here?
Old scratch.
Yaman El-Ahmad?
Good morning, Judge.
Good morning.
Half of Mr. El, say your name for the court.
Young officer.
So
You just need a new date?
yes,
Okay,
the arraignment, you stand, you really see other information.
all right.
Thank
You working? Go ahead.
He is requesting a court appointed attorney to reach out.
Okay, all right. You're working? Where at?
Lowe's.
How long you been at Lowe's? Heather, can we do a pretrial 212?
Yes, Judge Martin. Is his last name ELHMAD?
Yep. What time,
Fine to me, or we get different?
No, it's signs deal.
Okay.
who, or what time we doing that?
212 is gonna be 9:30.
And you said that's Judge Martin?
Correct.
All right. Sir, I'm gonna put you on a personal bond. First condition and second condition, both are kind of obvious. Stay out of trouble and show up for your court date. Third condition is do not purchase, possess, or consume any mood altering substance unless you've got a doctor's prescription. That means marijuana and alcohol are off the table. Understood? Can you abide by those rules? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you mess up on bond? Any questions? You're all set. Just wait a minute. We'll get you a paper notice. Haley, is it Matthew? Did I pronounce it right? Counsel?
Morning, Judge. Deanne Patillo, P 82378 on behalf of Ms. Matthews. State your name. Hazel Matthews. So you're not asking your name, fans, and you anyway reading. I have opportunity to discuss this matter with the prosecutor. There is an agreement to dismiss the original charge of operating while intoxicated, and Ms. Matthews would plead to operating while visibly impaired.
Thank you. Ms. Matthew, did you discuss with counsel your rights and options? You understand all those? You understand the possible penalty for the added charge? Understanding all of this, are you pleading guilty freely and voluntarily today? Counsel, if you would voir dire, I've got an incident date of October 9 this year.
Ms. Matthews, state your name for the court again one more time. And were you in the city of Van Buren Township on October 9th? Were you driving a motor vehicle? Prior to driving that motor vehicle, had you consumed alcohol? And do you believe that alcohol impaired your ability to satisfy?
I'm satisfied too. I'll dismiss the original charge. All right, Ms. Matthew, next step is I'm going to send you downstairs to the front counter. Probation is going to schedule for you to come back for an interview and a sentencing date. All right. I'll also put you on a personal bond in the meantime. Did you hear me do terms on the last one? First one is stay out of trouble. Second one is show up for your court date. Third one is, all right, raise your right hand. Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you screw that up? Any questions for counsel before I let you go downstairs? You're all set.
Thank
You're welcome. What was the name on that one I just handed you?
All right, let's change it up a little bit. Let's go over to 14B in Washtenaw, Magistrate Hillary Braley. Let's see what's going on there.
Yes, Your Honor, Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Shoei. And it looks like Mr. Shoei is currently on mute at the jail.
Okay, Mr. Shelley, can you state your name?
Frank, sure.
Okay, thank you. So today is the date and time set for an arraignment in this matter. And what I am seeing, it looks like you had it's a home confinement tether. And I've got a conditional release violation. I've got a police report here dated December 19th. Attorney Bukovich, do you have a chance to review that?
Yes, I did review the bond violation report that came in through the tether agent this morning with my client. And did speak about the alleged allegation.
So just so that I'm looking at this correctly, it looks like the address that was provided for the home confinement is an address that your client doesn't live at anymore.
Yes, from my understanding, to speaking to my client this morning, it was an address where he believed he had friends that he had friends, he knows people there, he believes he could have resided there. However, for whatever reason why he's unable to reside there right now, and I was going to address that when addressing my bond argument.
Okay. You may address bond.
Yes, Your Honor. At this time, Your Honor, I do maybe standing mute as to the allegations. I know today is not the time nor place to really discuss the allegations of the bond violation. However, I do want to note that in the report, it does indicate that my client was going to the address that he believed he could go to. There was the issue with whatever reason why he could not stay there. The one thing I want to highlight and stress is that he followed the court's orders, got in contact with JSC, and was compliant with police officers the whole time, ensuring that he was doing what the court asked of him. So I want to stress that my client is working to follow court's orders. Whatever misunderstanding happened here with the location should not fault my client for doing what he was supposed to be doing, going from the location to where he was supposed to go. He did provide me a good mailing address. He did provide me the good phone number of his boss. He does have part-time gainful employment. He does indicate to me that he does primarily live in a trailer on a lot. He just moved to trailer there, so he did not have the address for me this morning. However, he does have some form of residence. He does will be residing locally in Ypsilanti. So at this time, Your Honor, based upon my client's attempt to comply with that order and his inability to stay at that 1670 address, I was going to be requesting a person of reconnaissance bond. Even though this is labeled as a red bond violation, it's clear that my client was taking all steps possible to do what the court asked of him. So I believe this would be warranting of a GPS tether because it could alleviate any concerns the court has about tracking in my client's location and community safety for the alleged complaining witness in this matter, and allowing my client to return to his trailer and be able to handle this case from out of custody. Because I do believe he does deserve a second chance, particularly because he was doing what he could do to comply with the court order. And I do know that there is an ex-jail, a bond denied for that felony matter. There is a note in there that says he's not being held on that case, so I do not understand why it says bond denied, but there is a note in ex-jail if you click into the case that says he's not being held on that either. Yeah, it's a very weird thing, Your Honor. I just wanted to point that out.
Okay, thank you.
But yeah, I'll just reiterate my request for a person of reconnaissance bond with a GPS tether instead, because I believe my client is warranted of that second chance based upon his attempts to comply with that order.
I would note that this would be chance number 3, as there was a bond violation back in July regarding not reporting for testing.
Yes, I understand that, Anna. I was the APD that also addressed that one.
Your Honor, I have to be in court tomorrow. I will go to community corrections as soon as I get out of here. I'll do everything you want me to do. I was trying to.
So regarding, well, I guess a couple things. One is you've been ordered to go to testing. Are you able to do that?
Yes.
Okay.
Yes.
Because it's $12 to test.
Right.
With a photo ID. Okay.
Yeah, he is currently doing odd jobs, so he does have employment to help pay for testing.
Okay. And then the GPS tether being for home confinement purposes, we do need an address for that. So this Center Street address, Attorney Bukovich?
My client indicated to me that was an address for mailing purposes.
Okay. But if we're going to be releasing Mr. Shelley on a home confinement GPS tether, then we need an address that works for the home confinement.
I understand. That's why I was asking for it to be converted to a GPS tether, Your Honor. because he's currently staying in a trailer on a lot without a designated address. It's next to someone's property, so, but he doesn't have a call the address. He just moved his trailer there recently. So that's why I was requesting the GPS tether. Particularly because there was the attempt to go and comply with that court order, and he was in contact with the tracking services with no issues.
I have a phone that they gave me, but I don't know the phone number because I just had it for a few hours. It's in that property though. I can't give you that number. Ma'am, I will go to everything you tell me to go to and do everything you tell me to do. I'd like to just get this cleared up and be done with it. These things are like a year and a half old.
Mm-hmm.
And I understand that. I am going to point out that, you know, you were ordered to go to testing back in July and didn't report for testing according to community corrections. So that was when a bench warrant issued for you in August. It looks like the judge arraigned you on that on December 15th and put you on the home confinement tether, and we can see what happened with that. So if I give you one more chance here, that's gonna be the last one most likely, unless the judge.
Yes, ma'am, I do understand that.
Okay.
And we did have a conversation about that this morning, Your Honor, as well.
All right.
Your Honor, I'd just like to get this stuff over and done with, and
I can appreciate that, but part of moving things along timely is doing the things the court's telling you to do.
I understand. Yes, I do.
So
While we're waiting for Magistrate Brayley to finish signing a bunch of things, thank you to Barbara for donating $5 on the website. Very much appreciate that.
2026 at 9 a.m. We'll convert the tether to a GPS tether for tracking purposes. Your testing is continued as it was previously ordered. It looks like the judge wants you going to community corrections for testing 3 times per month, and it's to be ETG and substance testing. So, any questions as far as that goes?
No, ma'am.
Okay. And then I'm not sure if this was brought up before, but I am showing a very old no proof of insurance ticket for you. Did we talk about that previously?
I don't recall off the top of my head, Your Honor, if we did or not. Sorry.
Okay, so I'll just make sure that, yeah, well, here first, 05W165101C. It looks like you have a $45 balance. That would be the clearance fee on that. I'm gonna set that for the same date and time so that they can be dealt with together. Okay, January 5th, 9 a.m.
So that's a $25 clearance fee I have to pay?
45.
45?
Yeah. Okay. All right, Attorney Bukovich, anything else or any clarification needed on anything?
I don't mean there's any clarification needed on my end, Your Honor. And if it's for my client's reference, remember tomorrow your court date is at the 14A1 district court, not at the 14B court that we're talking about right now. Okay, sir?
So do I get to go home today or?
Well, so I'm granting a personal recognizance bond in this matter. So it's going to be a $20,000 personal recognizance bond. So if you don't show up or if there's another bond violation between now and January 5th, then your bond's going to be at minimum $20,000. All right. But that means this case won't hold you at least.
It's the only case I have.
Okay, then there you go. All right. If you don't have any questions, you're free to go to the door. Thank you.
Thank you.
All right, let's change it up again. We'll stay with the magistrates, but let's go to Clayton County, Georgia this time.
All right, Mr. Bice, you were charged with obstructing law enforcement. That bond is $500. Simple assault is $500. Your total bond is $1,000. Your next court date is on January the 20th. If you do not bond out, if you make your bond, you'll receive notice in the mail when to come back to court. And let's see here. Based on your application, I've appointed an attorney to represent you. Do you have any questions?
No, ma'am.
All right, thank you.
Thank you.
Go to bed. Next one, come on, Miles.
All right, what's your last name?
My last name is Dials.
All right, Mr. Downs, you were charged with afraid. That bond is $1,000. Riot in an institution is $4,000. Your total bond is $5,000. Your next court date is on January the 21st. I've appointed a lawyer to represent you. Do you have any questions?
Yeah.
All right, thank you. You said yes.
I got a question. So I was in a dorm and a trustee with a white jumpsuit, he came in the dorm. I had my hands inside my jumpsuit.
You can't talk about the case.
And I don't know why I'm getting charged.
Okay, I'll let you know what the allegations are. The allegations are that on December the 20th at approximately 10:55, it was observed that there was a fight between two inmates, yourself and Zuriel Ash. After reviewing the camera, inmate Ash was seen slapping inmate Dowles in his facial area and slamming him on the day room table and knocking him unconscious. Inmate Dowles had a swollen lip, swollen ear, and scratches on his face. Inmate Dowles was cleared by Nurse Ote. It was determined for him to be placed in the infirmary until further evaluation. Camera footage was placed in the vault. That's what they charged you with.
You see why I don't understand why I'm getting charged.
Yeah, so it looks like they're trying to indicate, I guess, that it was a fight, but the other person obviously was the aggressor. Yeah, they didn't even put anything here about you. You're absolutely right, Mr. Dowles. Your charges are dismissed.
Thank you.
You're welcome.
Wow. Tell me the last time we've seen somebody argue in front of a magistrate or judge like that, and the judge or magistrate go, "Yeah, you're right, charges dismissed." I'm shocked. Let's keep watching. This is interesting.
Huff, all right, hold on 1 second, Mr. Huff. All right, Mr. Huff, you were charged with possession of prohibited items. That bond is $5,000. Your next court date is on January the 21st. I've appointed a lawyer to represent you. Do you have any questions?
Ma'am,
All right.
so I got the same charge, right? He owned up to his stuff, right? So I don't know.
That's not in the, that's nothing about owning up is in the warrant about your case. It just says that they located tobacco products without authorization on your person. So it don't have anything about that on your warrant.
You can check the body cam, ma'am. So the body cam.
I'm not gonna check the body cam. I've appointed you a lawyer. Your lawyer can check the body cam on your behalf and bring it to court. If you walk off now, I'm gonna revoke your bond. You don't walk off from court when I'm still talking.
Officer just told me to come on.
Okay, I didn't hear that. All right, thank you.
What's your next one?
Hold on 1 second. Right. What is your name, please?
Michael Martinez.
Martinez. All right, 1 second, Mr. Martinez. All right, Mr. Martinez, you were charged with criminal trespass. Your bond is $500. Your next court date is on January the 20th. If you do not make your bond, if you make your bond, you'll receive notice in the mail when it come back to court. It indicates that you do not want to be considered for a court-appointed attorney. Is that correct?
Yes, that's correct.
Okay, so I'll indicate here that you're going to hire your own attorney. Do you have any questions?
Yeah, I don't know. For some reason, the officer said I would have a signature bond, but I don't. Based on the charges, is that was just his opinion? I'm assuming.
Yeah, so family violence charges, the governor of this state does not authorize signature bond on those class of charges. So you didn't qualify based on that.
Okay, and then if I could pay it on my own, however, my debit cards, credit cards.
Yeah, jail they don't take debit credit cards, but you could facilitate it where you can release your property to someone on your behalf to facilitate that for you.
Oh, okay. And I guess they'll let me know how to do that.
Yeah, so you would just have to release your property to somebody, whoever you trust, to get the money for your bond.
Okay.
All right. Thank you. Good luck. All right, what's your name, sir? The last name?
Porter.
You said Porter.
Porter.
All right, Mr. Porter, you were charged with possession of prohibited items. Your bond is $4,000. Your next court date is on January the 21st. If you do not make your bond, if you make your bond, you'll receive notice in the mail when you come back to court. Appointed a lawyer to represent you. Do you have any questions?
Yes, ma'am. That was my roommate that was on here.
Mm-hmm.
Charged it right when they found everything. So that did say that.
It doesn't indicate it. It just says that you were found in possession of tobacco. It doesn't sort out who had it, but that you were in possession of it. So that's something you'll have to dispute at your preliminary hearing.
Oh,
all right. Anything else?
Oh, man.
All right. Thank you. Take care.
Now, we got one medical personnel that medical emergency. So
you said who is that?
Peterson, ma'am.
Peterson?
Yes, ma'am.
So you're saying Peterson is in medical?
Yes, ma'am. He had a medical emergency.
Didn't see anything. Okay.
Your Honor, do you have an add-on for a trace?
Yes, I do.
What X? X what? Email. Fine. You got one more person, come see, man.
All right. All right, what's your name, sir?
Ash.
Ash. All right, Mr. Ash, you were charged with a fray. That bond is 1,000, and rioting in the institution is 5,000. Your total bond is $6,000. Your next court date is on January the 21st. I've appointed a lawyer to represent you. Do you have any questions?
No.
All right, thank you.
How's Unit 5? What's up behind you?
What's your name?
Margot Broderick.
Anybody else on 5 on first offense?
No.
What about 7 and 3?
All right, Mr. Broderick, Miss Broderick, you were charged with criminal damage in the second degree. The bond is 1,000. Battery is 2,000. So your total bond is $3,000. You have special conditions that you can't have contact with jamming and costing. Do you understand that bond condition?
Yes, ma'am.
Your next court date is on January the 21st. If you do not make your bond, if you do make your bond, you'll receive notice in the mail when it come back to court. I've appointed a lawyer to represent you. Do you have any questions?
Yes, in the regards to the no contact. That's my husband. We live together. How do we go from that? So we live in the same household with children, little ones.
Yeah, so I didn't order you not to live in the residence. You just can't have contact, so he will not be able to come back to the residence, and you'll have to use a third party to facilitate whatever you're gonna do with your children, because both of you have been ordered not to have contact with each other.
So that means he cannot come back to the house.
Not until the solicitor and or your attorneys have an opportunity to investigate the scenario, because you two are both here because of the allegations that are based on both of your actions.
Okay. And
So somebody independent of the court who has no way to verify anything right now. So we have to do no contact until somebody from the state and also your lawyer can see if contact is appropriate.
Okay, can that be done before the court date or before?
Yes, it can.
Okay, and we just get the lawyer to contact the court in regards to that?
Yeah, so your lawyer will know what to do that I've appointed to represent you.
Thank you.
All right, you're welcome.
Hey, that's what. Come on. Thanks, man.
All right, what's your last name? You don't want to tell me? All right, next person. I don't have time for all this, baby. We got 50 people. Next.
Y'all didn't hear my name?
Did you say you? I didn't hear you.
She said Charles.
Okay. All right, Ms. Charles, you've been charged with possession of marijuana less than 1 ounce. Your bond is $3,000. Violation of Georgia Controlled Substance Act is $3,000. So your total bond is $4,000. The marijuana charge is $1,000. Your next court date is on January the 21st. If you do not make your bond, if you make your bond, you'll receive notice in the mail when it come back to court. I've appointed a lawyer to represent you. Do you have any questions?
No, ma'am.
All right, thank you. Take care.
Who's that?
All right, what's your name?
Aaliyah Davenport.
All right, Ms. Davenport, you were charged with simple battery. Your bond is $500. You cannot have any violent contact with Malik Davenport. Do you understand that?
Yes, ma'am.
Your next court date is on January the 20th. If you do not make your bond, if you make your bond, you'll receive notice in the mail when it come back to court. You'll have to hire your own attorney based on your income. Do you have any questions?
Yes, ma'am. Am I eligible for a signature bond? I'm not really sure what it is, but I just.
No, because your charge is family violence. The governor doesn't allow signature bonds on any type of charges that are classified as family violence. And it's classified as family violence because the alleged victim is your brother. So you can't get one just because that's what the governor said. Do you have any other questions?
No, that's it.
All right, thank you.
Thank you.
Come on. All right, what's your last name? Good. All right, you were charged with criminal trespass on unlawful purpose. Your bond is $2,000. You cannot go back to 1070 Helen Street in Forest Park, Georgia, as a condition of being granted bond. Do you understand that, ma'am?
Yes, ma'am.
All right, your next court date is on January the 20th if you do not make your bond. If you make bond, you'll receive notice in the mail when it come back to court. I've appointed a lawyer to represent you. Do you have any questions?
No, ma'am.
All right, thank you. All right, what's your last name?
Howell.
All right, Ms. Howell, well, fortunately for you, the officer did not complete the paperwork correctly. So as a result, your charges have been dismissed. I do want to warn you that it's possible the state could have the officer correct the charges at a later date. So don't be surprised if you get something in the mail later. But for purposes of today, the case is dismissed and you'll be released sometime today.
Thank you so much.
All right, you're welcome. Take care.
That's 2 charges dismissed. Need to keep count now.
All right, Ms. Matthews, you were charged with armed robbery. That bond has been denied, and you were charged with battery. That bond is $5,000. Your next court date is going to be on January the 21st. You'll have a bond hearing date if you don't get a bond before then on January the 23rd. I've appointed a lawyer to represent you. Do you have any questions?
When is my bond hearing?
The bond hearing is on the 23rd. Your preliminary hearing is on January 21st.
Yes, ma'am.
Any other questions?
Yes, ma'am. My attorney will come see me before then.
Yes.
All right, thank you.
You're welcome.
Good morning, we're back. As I mentioned, this is a pretty full day. There's no pre-Christmas lull here. We're gonna get right to it. Ms. Canfield is here. The defendants are here. Here we go. I hope you like today's first line. It's a good song to sing along to. Good morning, Mr. George. I'm good. All right, we have 2 cases set for this morning, one with Mr. George and one with Mr. Bush. One with Mr. Truckee. But we are ready to address People versus Daniel Geary. Mr. Geary, why don't you come up and have a seat with your attorney, Mr. George.
I just slipped in the shower, put some growth in it.
All right, well, I'm sorry to hear that. I'm a little crooked today myself.
Yeah. You know, at 55, I don't know how many more falls it's gonna take for him. I say no. Like my mom, she's almost 80 and she still does not say no, you know? On projects. She usually lift boulders like that, you know? Landscaping her
All right, well,
property.
give me a minute to get caught up here. This is file 251979 SM, People versus Daniel Gary. Mr. Gary is here with his lawyer, Mr. Tim George. Mr. George has represented Mr. Gary in the past, and has had a good attorney-client relationship with him. This matter was charged with domestic violence and interfering with a crime report for an incident that occurred on August 6th. The matter was set for a pretrial conference, then was actually set for jury trial. The defendant entered a plea to disturbing the peace. That plea was entered on December 10th. The other charges were dismissed. Disturbing the peace is a misdemeanor punishable by up to 90 days in jail and a fine of up to $500. I left in place a no contact provision with Ashley Brown, who was the complainant in this case. Mr. Gary had a previous disturbing the peace that he had been delinquent in his payments. So I adjourned the matter for a couple reasons. I wanted to have a no contact provision remain in place, and I wanted to see whether Mr. Gary continued to pay on his fines and costs.
Yeah, they should be all paid.
Well, I reviewed this morning, you made an October payment, you made a November payment, and you made a December payment. The last payment I saw was December 3rd. There's something more than that. So he was paying on his earlier disturbing the peace. He did spend 2 days in jail in this matter before he was released on a PR bond. I was troubled. Mr. Gary had continued to have contact with Ms. Brown, I think through the period up to the plea. So I entered the plea. Mr. Gary then walked out of the courtroom, went outside and called Miss Brown for a ride. And the bailiff said, "You can't do that." And gave him a bus pass. So I haven't heard anything since, but
that lady officer told her not to come. She was giving me the bus.
Well, true. I was like 1 minute later, you went out and did exactly what I told you not to do. Now, I do know that you suffer from autism. I don't suffer, you deal with it. You've been dealing with it your whole life. And you're on the spectrum. You also have some other mental health issues that you've been trying to address.
Yeah, in jail, you don't get your medication. So I mean, it's gonna be really,
So this was reduced to a disturbing the peace, which is normally a fines and costs circumstance. Mr. George, what would you like me to know?
Thank you, Your Honor. And I know that the court has concerns, and I think the prosecutor had relayed those as well regarding some of the contact that had taken place. I think from Mr. Gary's standpoint, he's concerned that if there was any jail time that was imposed, that he wouldn't have the ability to access his medications that he takes. I think for him, at least in the last few conversations we had, his biggest.
Just a minute, Mr. Gary, we'll give you a chance to speak. You need to.
I think he's focused on trying to get things together as best he possibly can to get out of here, get the house sold, and move on. And maybe that wouldn't be a bad thing to change his scenery. I think if the court were, considering some alternative sentence other than the fines and costs, we would ask for a probation instead of the jail time. That would allow the court to continue supervision. If there were any type of services that the court think that Mr. Gary could engage in, that would help alleviate some of those concerns. Those could be done over the course of that probation. But I think the biggest articulated reason for it would be continued supervision from the court to make sure that any orders of this court would be followed. Thank you.
Ms. Camfield, do we have any updated information from Ms. Brown?
Yes, Your Honor, my office has had continual contact with Miss Brown on the date of the plea, which confirms the information that we all suspected. He'd been living in the home the entire time this case was pending, having contact with her on a daily basis, including on the day that she authored the victim impact statement to this court. That's extremely concerning to me because that's obviously not done of her own free will or done in a setting where she felt safe to communicate with our officer, the court. The first time that
Just a minute,
Daniel.
She's right here in the building. You can talk to her right now.
I'll give you a chance
She's in
to
the building
speak.
right now.
She's in the building, you
Yeah,
said?
she has to take care of because the paperwork and she got notarized
All
correction
right,
doing
so
right now.
just a minute. Is she here in the building?
Sure, you have to take care of her so we can get this house sold and get out of it. You'll move on.
Yes.
I think she's at the. At least a couple hours away, you know?
All right, would we see if we can find her?
Yeah, she's right up there.
Her name is Ashley Brown. She may be at the Register of Deeds. All right, Ms. Campfield.
Thank you, Your Honor. And what's more concerning also is that this isn't the defendant's first contact with the court. It's not as if he hasn't been in trouble before and understands the court's orders. He was on probation for drunk driving in 2016. He had a use of narcotics and an attempted resisting and obstructing in 2019, for which he received 90 days in jail. And then he damaged a traffic device and pled guilty to that in 2023. Now we're here in an incident where, yes, it was resolved with a disturbing the peace, but it was because her phone was grabbed out of her hand and she was headbutted by the defendant, and neighbors were involved in seeing this occur. So in this particular instance, he also was to have no contact. He's violated that the entire time the case is pending, inclusive of the day of the plea when the court specifically instructed him, do not have contact with Ashley Brown. And then you go out and use a.
I get the statement off because she's saying somewhere else. I'm new here.
All right, just a
Yeah, I
minute.
have nowhere to go. She
Daniel,
had to get gone.
Daniel, I'll give you a chance. I'll give you a chance to
So
speak.
she came over on her free will, you know, she knew better. She
All
had, you know, she had.
All right, Daniel, just wait.
Okay, sorry, sir.
All right.
Thank you, Your Honor. He just repetitively violated this court's order, specifically after the court told him not to, and he went and used the security phone to call the victim.
Yeah, because she took off with
Stop,
it, and
stop.
she owed me $300 for gas, I mean, for
all right.
water bill. And she goes and spends it all with Josh Brown.
Your Honor, so
They come back, yeah,
clearly.
and with
All
my
right.
cell phone.
All right.
It's my cell phone. I was the one with 2 hours without it, them 2 hours, they're counting on my phone.
All right, Daniel,
All right.
calm down.
There is not a
She's right
circumstance
here, she'll verify that shit.
All right.
in which she is safe, given the emotional status of the defendant.
Yeah.
Yeah, just 15.5 years in
All right.
Westville.
All right.
See how you feel. Okay?
Put Mr. Gary back in the lockup.
Yeah, please, I need a break.
Yes. We may give you a break till about Valentine's Day. I want you to go back there and calm down.
brother.
And Your Honor, I understand the defendant has mental health diagnoses, but we also have to make sure that the public and Ms. Brown are safe, in addition to the defendant not being a risk to himself.
I'd like
I
to
am
hear
gonna
from her.
request a jail
It's
sentence.
always a problem when we take a plea to a reduced charge and then ask for a maximum sentence on the reduced charge rather than the larger charges. But I don't know what side of the fence Miss Brown is on, so I'd like to hear from her. But he's gonna talk himself into about a 30-day jail sentence. So we'll see if he calms down a little bit, and then we'll wait for her.
There was an impact statement submitted from Ms. Brown requesting jail, Your Honor.
I did review it. All right. Mr. George makes a good point. When he goes to jail, they tend to not give him his medication. And then that causes further issues, but they're doing a better job than they have been in the past. Mr. George, if you'd wait for a minute, we'll see if we can find the complainant and we'll take up Mr. Truckey's case.
Yes, sir. I had broke a call to register deeds and she was not over there, so.
Do we know if she's come in the building?
It looks like Miss Ackerman may be trying to communicate or look for her as well.
Okay. All right. Let's move ahead to our next case, which is Dakota Suarez, file number 252297. Mr. Suarez is here with his lawyer, Mr. Ross Truckey. Defendant entered a plea to domestic violence. He was arrested on this charge on November the 9th. Posted bond on November the 12th, so I think there's 3 days of jail credit. The defendant is only 22. He is eligible for the deferral. This was in his relationship with Hannah Lamb. And there was a witness there when this occurred, Mr. Orion Fogg, and Miss Lamb has some emotional issues of her own. Mr. Suarez trashed the apartment, lost his temper, and there was some impermissive touching, and he pled to a charge of domestic assault. Mr. Truckey, what would you like me to know?
Thank you. I think this is the kind of person that the deferral program is meant to help, to intervene in before things get worse. This was a situation where there was drinking going on. All the parties were some level of intoxicated. Things got clearly out of hand. Mr. Lamb or Miss Lamb and Mr. Suarez had an altercation. He came in here, he pled to it. He recognizes that it's not how he wants to live and how relationships should look in his life. So we're asking for the court to sentence to the deferral program, allow him to gain some skills and some perspective on how healthy relationships work and move forward. Thank you.
Thank you. Ms. Campfield, what's your thought?
Thank you, Your Honor. Well, I can say that Hannah is present and would like to address the court. I do think this situation is appropriate for the 769.4A diversion probation. At the scene during his interview, Mr. Suarez appeared to be very upset, very remorseful for what had occurred, and I think acknowledged that he lost his temper. I know that she would like to have contact, and I'd like to have her come up and speak to the court regarding that.
I set this on purpose to do it before Christmas. In fact, both of these I did. And which case are you here on, ma'am?
I'm his mother.
Oh, all right. Any luck? All right. Well, okay, very good. All right. Miss Lamb, what would you like me to know?
So that night we had gotten drunk. We were just hanging out with a friend. And me and him had gotten into an argument over his friend talking to one of my friends that wanted no contact with.
Well, here's the way I saw it, that you confronted him because he had some other woman in the apartment.
No.
And then he went ballistic after that.
No.
So that's what the police report says.
No.
So what actually happened?
So what actually had happened was me and Culotta were at home and we were drinking. We had his friend.
What were you drinking?
Huh?
What were you drinking?
Steel Reserves.
Okay.
And we were drinking those. I think he may have had like 3 or 4. I may have had, I don't even know. But we were drinking. He had his friend over. One argument started because his friend wanted to take him to his house, and I was just hoping he would have just stayed at home. And then we were just sitting in the living room, and then he had his friend Orion had said that he wanted to talk to my friend who lives with me. Her name's Alyssa Klusterman. She lives with me, and he wanted to talk to her, but she wants no contact with him. And so I was telling Dakota that, he shouldn't, his friend shouldn't have contact with her because it's not something she wants. And something had set him off, and he started going ballistic, and we started yelling back and forth. And then I had gotten up to go to the kitchen to get away from him. And that's when he had jumped in front of me and grabbed a hold of both of my arms. And that's when I told him to let go of me. And the argument had continued to where I had gone into a different bedroom. And back in the living room, he was like, going ballistic. He was flailing his arms and his.
What do you think he was so mad about?
I don't know.
Well, I'll ask him here in a minute. Miss Klusterman wasn't there, was she?
She was there.
Oh, where was she?
She was in the. No, she wasn't.
She's not mentioned in any of the reports.
She was coming and staying at my house once in a while, but she was out walking around at this time.
Okay, so she wasn't there when this whole thing went
No, she wasn't
down.
there when this whole ordeal happened. And he was flailing his arms, and his watch had actually come up. He was flailing his arms around. His watch had actually come up and hit me in the underside of the arm. And I had said that he had hit me. And so I had walked into a different bedroom, and I was saying, like, dude, you hit me, you hit me. Why would you hit me like that?
Who called the police?
I did.
Okay.
And we were in that other bedroom, and then that's when he had said, like, oh, if you want me to hit you, I can. He raised his fist and pretended like he was gonna
Yeah,
hit me.
something like, you want to see how hard I can really hit you.
Yeah. And then that's when I had walked out of the bedroom, and then that's when he started destroying my house and everything. And then that's when he was like, oh, you know what, just do it, just call the cops. So I had called the cops.
Now, did he live there or just come sometimes?
He lived there.
Okay, so you were both living at Spring Street?
Yes.
Okay.
And afterwards, he was trying to get Orion to get him to leave before the cops showed up. And then Orion wouldn't take him anywhere. So he just kind of laid on the couch and just kind of accepted it. And then the cops came in and
Yeah,
talked to us. And
he's
then
just
that's
laying
when
there.
we-
So do you want me to lift the no contact provision?
Yeah, I
So-
would. It was an accident. We were all drunk, and he was, it was just a bad night. I don't believe he has any intentions of hurting me.
Are you employed?
I will be soon at American Axle.
And
I'm just
was-
waiting
Was
for-
Dakota employed?
No,
All right, we'll talk to him about that. All right, I'm glad you're here. Thank you. Mr. Suarez, I can only do that deferral if the prosecutor agrees or accepts it. And in this case, they do. Nobody drinks Steel Reserve because they like the taste. They drink it to get drunk because it's relatively inexpensive and it has a high has a high alcohol content. So you guys were there, having drinks and get drunk, and then many of my stories start out that way. If I took alcohol out of the equation, I'd probably have about 1/3 of the cases I currently have. You've not been in any trouble. You're 22. You're eligible for a deferral. When's the last time you worked someplace?
Like about a year.
Why not? All right, well, maybe it's time to go to work.
Yeah.
I asked her, she didn't know. Why were you so mad?
Cause she was taking her, like, talking, like, she was like, just like coming at me instead of talking to him, like Orion, and like, I don't know, it was just, I was defend, like, I was like, I don't know, it was like, I was like trying to defend him a little bit, cause they're like, it is, I don't know. Like,
Well,
I was
alright.
upset because she should have, like, like I was trying basically to tell him like, I don't know, talk to him about it, the situation instead of coming at me. Like,
Well, I'm not sure I have any clearer understanding now than I did then. You did 3 days in jail. I'm gonna put you in the anger management plan. You could use some anger management. If you complete this probation, you're not gonna do any more jail. And you're gonna have the charge taken off your record. I'm gonna order 13 days jail, credit 3. Of the 13 days, 10 are deferred. I got 10 days hung over your head. The fine is 0. There's enough other stuff you have to pay for. There's a $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee, $480 probation oversight fee, which can be cut in half if you do it in 6 months. You're gonna pay for the class. So one of the things you have to do is get a job. I'm not sure how a 22-year-old lives for a year, as girlfriends without working somewhere, but it's time for you to get a job because you're gonna have to pay for this stuff. 125 in costs, 150 attorney fee, 480. It's 755. And you're to pay for the anger management class. No assaultive or threatening behavior. Alcohol and drug testing as directed, because while you're on probation, you can't use any drugs, including marijuana, and drink any alcohol. You're old enough to use marijuana, you're old enough to drink, but we call this a timeout. If you can complete the anger management class within 6 months, I can discharge you from probation at the end of 6 months. I'm gonna lift the no contact provision. But there is a clause of no assaultive or threatening behavior. So even if you don't hit her, what you did trash in the apartment would constitute assaultive or threatening behavior. So as your lawyer said, we're gonna give you some tools to kind of deal with these anger issues. But you guys are entitled to go out to lunch together. You're entitled to live in the same house. I'm not prohibiting it. What kind of work have you done?
I worked like Meyer, like at other like I've been cashier at a couple stores like Dollar General, Meyer.
I was going to ask you to try to give me a sentence without saying like, but I don't think you can do it. But I think that you're going to be all right. I think you're going to do what I'm asking you to do. I think you're going to complete this probation. I'm going to take this charge off your record. All right, let's take this form downstairs to the probation department. I think I have a little bond money in here. You posted $200 in bond. So you'll $555, and if we subtract $240 from that, would be about $315 that you'd owe in 6 months. And the class, I think it's like $600, is my recollection, but the probation department will help you with that. All right, you're good to go. Take that down to probation. You guys can go back home together. You can go out to lunch together. I want you to treat her with respect. Christmas is coming. We don't need any of this. No drugs, no alcohol. So you can help him. You can't be sitting there drinking beer and he can't drink. So maybe you can both take a time out. Be good for both of you. All right, you're both good to go.
Thank you, Your Honor.